Hey everybody. This is going to be a continuation of the wrongful conviction story of Andrew Hayes. So what we're going to be looking at today is the latest petition, the Coram Nobis petition. That means it's going to the trial court level first. We'll see what the trial court thinks. But we've already heard from what we watched yesterday from District Attorney Steve Mulroy. He will not be fighting any efforts from Andrew Hayes' team to overturn this conviction. And we'll have to see how the legal proceedings play out. But I think he has a really good shot, and now it's just a waiting game. You can watch this stream without watching part one. I don't think the order that you watch it in will matter, but if you do want to check out the docket deep dive where we looked at, the case background, all of the previous appeal efforts and post-conviction relief efforts that were exhausted and or denied and or dismissed, or not even heard. They couldn't even get a certificate of appealability for some issues. You can watch that all in part one. But this is really going to focus on this new petition for writ of Coram Nobis. One thing, I showed you guys this Gamma document. It's linked in the description. It compiles everything that we talked about. I did add one thing yesterday, and we might watch it at the end of the stream. It'd be out of order if we were to start with it. But I did find the oral arguments for when we did the 2013 petition for post-conviction relief. The trial court denied it, and then Andrew Hayes and his team at the time appealed it to the Court of Appeals, and there were oral arguments. I actually went and looked because I was wondering if it'd be Amy Wyrick that did the oral arguments, because she's listed for the state on the briefing, but it was, I think Gichner was his last name that did that. So we might listen to this at the end of today's stream. It's also in that Gamma. We did not hear these yesterday because I didn't know they existed yesterday. So there's that update there. But for what we're really here for, this was filed January 6th of 2026, so a couple weeks ago. We are at the trial court level, so Criminal Court of Tennessee at Memphis in the 30th Judicial District, Division 1. And again, now it's Andrew Hayes v. State of Tennessee, because they're the one making the petition against the state here. So, petition for writ of Coram Nobis comes now the petitioner Andrew Hayes. Let me make this bigger. Let's see. Over here. There we go. All right, there we go. So Andrew Hayes, by and through undersigned counsel and pursuant to the Law of the Land Clause of Tennessee Constitution, Article 1, Section 8, the right of a writ of Coram Nobis contained in the Tennessee Code Annotated, Section 40-26-105, and respectfully moves this honorable court for an order granting a writ of Coram Nobis, vacating the conviction and granting a new trial. So I'd be curious to see if the conviction's vacated, if they even pursue a new trial against Andrew Hayes. If you missed yesterday, Steve Mulroy announced that charges had been issued against Sarah Lucas Reidel. We're going to hear more about her confession in this document, and that she was already being held in a correctional facility in Oklahoma, and they're just waiting on extradition because Sarah wouldn't waive extradition. But they said they plan to have her in Tennessee by the end of this month, so we'll see. But I'd be here. I'm pretty confident that they would not retry Andrew Hayes. On June 25th, 2024, Mr. Hayes filed a joint petition for writ of Coram Nobis and motion to reopen his post-conviction petition based on new evidence of Mr. Hayes' innocence. Now remember, this was denied. We looked at that yesterday. On October 25th, 2024, Mr. Hayes submitted an amended writ of Coram Nobis petition. They're going to call that the 2024 petition, and an amended motion to reopen the post-conviction petition at the direction of the court. On November 15th, 2024, the court denied both petitions. On November 12th, 2025, the Court of Criminal Appeals upheld the denial of that 2024 petition. Investigation of the case continued throughout 2024 and 2025, and this is largely all kudos to Jason Gichner and his team with the Tennessee Innocence Project, as well as Stephanie Tinsley, who did a ton of work and put together the story, everything that she looked at in her podcast, Everything They Missed. That's linked in the description. I loved listening to it. You guys have given great feedback, so please check that out. It's about 3 hours of time. So if you're looking for something to do with your evening tonight, check that out for sure. So investigation continued, and new additional information on Mr. Hayes' innocence came to light that definitively proves his innocence. The new evidence consists of recorded statements by a woman confessing to the murder, the same murder for which Mr. Hayes is serving a life sentence. The recorded statements unequivocally exclude Mr. Hayes as a participant in the crime and definitively prove his innocence. As of the date of this filing, the woman has been indicted and arrested for facilitation of first-degree murder. So there we go. There we go. Mr. Hayes does not waive any claims for relief not yet raised or presented fully herein, and respectfully moves for the right to amend his petition if further investigation or discovery prior to hearing reveals additional grounds for relief. Investigation of the case is ongoing. So they do this table of contents here, and their main arguments here are going to be that due process requires tolling of the statute of limitations, as Andrew Hayes is presenting new evidence. So when we watched the oral arguments yesterday, we saw the justices push back that there wasn't new evidence. How would this be new? And even if it were new, how would it change the outcome at trial? Because the jury heard Tammy Vance say that her daughter may have been involved. So how does this change? How does this evidence exclude Andrew Hayes? And quite frankly, the oral arguments kind of pissed me off, but on the part of the judges. But they ultimately deny it by saying the evidence that they had at the time of the 2024 petition wasn't actually something new to start the time counter over. And then B, the newly discovered evidence satisfies the requirements of Section 40-26-105 because it is new, admissible, and credible. As such, Mr. Hayes is entitled to relief on the merits of the statute. So let's read. If you did not tune in yesterday, this introduction should give you enough of a background to understand what happened with this case. So all the way back in August of 2010, Andrew Hayes was wrongfully convicted of a murder he did not commit. The victim was a man named Danny Harris. In September 2025, the daughter of Mr. Hayes' co-defendant confessed that she committed the murder with her mom, Tammy Vance, and that Mr. Hayes was innocent and not involved in the crime in any way. As of the date of this filing, she's been indicted for her participation in Danny Harris's murder. Danny Harris was killed on August 20th, 2007, but his body was not discovered in his apartment until October 26, 2007. There is no physical evidence that connects Andrew Hayes to this crime. No physical evidence. His conviction was based upon a factually incorrect quote-unquote confession obtained by the Memphis Police Department after a series of improper interrogations over an approximately 27-hour period. Mr. Hayes was not represented by counsel during these interrogations. The interrogations were not audio or video recorded. It is well documented by multiple witnesses that he broke down, hysterically crying through the process. Mr. Hayes has a full-scale IQ of 62, so third grade reading level. The other person charged with this crime was a woman named Tammy Vance. Miss Vance was Mr. Harris's live-in girlfriend prior to the murder. So Tammy Vance is Sarah Lucas Reidel's mom. Tammy Vance was living with Danny Harris, the victim, on and off again until the murder. Miss Vance entered a guilty plea prior to the trial of Mr. Hayes. She voluntarily accepted a life sentence. Two competing theories were presented at the trial as to who murdered Mr. Harris. Relying on Mr. Harris's coerced confession, the prosecution alleged Mr. Hayes, working with Miss Vance, killed Mr. Harris as part of a planned robbery. Miss Vance testified on behalf of the defense, claiming that her adult daughter, Sarah Lucas, committed the murder in an unplanned act of rage. The jury did not credit Miss Vance's testimony and convicted Mr. Hayes. Mr. Hayes, I think it's episode 4 of the Everything They Miss podcast, but Stephanie Tinsley goes and speaks with some of the jurors, and it's, in a sad way, it's really enlightening what she captures in that episode 4. So definitely recommend listening to the whole thing. But if you're wondering what the jury was doing, they share their thoughts with Stephanie Tinsley on episode 4. Mr. Hayes' previously filed 2024 petition contained evidence discovered years after the trial, showing that Miss Lucas likely confessed to her involvement in this murder to her family, that Miss Lucas's entire family knew she was involved in Mr. Harris's death, and that Miss Vance and Miss Lucas conspired to send an innocent man to prison. The 2024 petition was denied in part because the new evidence did not adequately exclude Mr. Hayes as a participant, and thus did not satisfy the tolling requirements of Clardy v. State. There's a footnote here that says the 2024 petition was further denied on the grounds that the new evidence did not fundamentally strengthen Mr. Hayes' defenses, and therefore did not establish his actual innocence, as required under the Clardy tolling analysis. So remember, in the post-conviction space, the burden is toppled around. Like, you have a high burden as a petitioner to make the case that, here's some new evidence, this is why it should be considered, it goes to my innocence. It's not when you're at trial, you have the benefit of the state having the burden to prove beyond a reasonable doubt their case. Then we've got, let's see, where was this footnote? Okay, so we were here. So they reference back to the Coram Nobis, the previous petition, and the decision from the Tennessee Criminal Court of Appeals. But now the current petition contains audio recordings. So here we were working with a letter that was found. And there was an issue of, well, wouldn't that be a hearsay issue? And they argued about that a little bit during oral arguments. But now we have audio recordings of Sarah Lucas herself, not just a letter from Tammy Vance sent to another relative. And then Sarah Lucas is confessing to her direct participation in Danny Harris's murder and her admission that Andrew Hayes was not involved in the incident at all. On June 19th, 2008, Andrew Hayes was indicted for aggravated robbery and first-degree murder. On August 21st, 2010, after a 6-day jury trial, he was convicted of both indicted offenses. The Tennessee Court of Criminal Appeals subsequently affirmed the conviction in August of 2012, so the direct appeal failed. The denial of Mr. Hayes' first petition for post-conviction relief was affirmed by the Court of Criminal Appeals on June 28, 2007. Mr. Hayes filed a pro se petition for a writ of habeas corpus in the Western District of Tennessee on January 29, 2018. The district court denied the petition on March 24, 2022. So part one, the video we did yesterday, goes through that whole timeline, like all of the attempts and denials. On June 25, 2024, Mr. Hayes filed a joint petition for writ of Coram Nobis and a motion to reopen the post-conviction petition. On August 29, 2024, the trial court issued an order to separate the joint proceeding into two distinct matters. So the two petitions become individual cases, and on October 8, 2024, the court requested supplemental briefing concerning the new decided case of Clardy v. State. So then on October 25th, Mr. Hayes filed an amended motion to reopen the post-conviction petition, which was the 2024 petition, and a supplemental brief addressing the Clardy tolling standard. And then the trial court denies both petitions anyway on November 15th, 2024, without an evidentiary hearing. So that's the appeal. They appeal this denial. And that's where we heard oral arguments. So this appeal of this denial of these petitions, we get this oral argument that we watched yesterday, where it was Jason Gichner arguing to the panel of 3 judges. And then the appeals court affirms the denial afterwards. Now in December of 2025, so remember, between this whole time period, the Tennessee Innocence Project and Stephanie Tinsley and anyone else involved, they're continuing to investigate. And the stuff they're investigating is covered in depth in Stephanie's podcast. So they're still trying to look for a way to help Andrew Hayes. Even though they've had to tell him time after time, court said, no, sorry, your appeal was denied. Like, I can't even imagine what it felt like to walk in and tell Andrew Hayes that, hey, even though we found a letter from Tammy Vance saying that she took the plea to protect her daughter, and her daughter's the one that did this, that, and the third, doesn't matter, court shut it down, you're still stuck with a life sentence. Like, I can't even imagine. So fast forward, sort of, to December of 2025, that's right around the corner from where we are today. It says, after being made aware of the same evidence contained in this filing, the Shelby County District Attorney's Office indicted Sarah Lucas for facilitation of first-degree murder for the death of Danny Harris and aggravated perjury at Mr. Hayes' trial. So, shout out we get a perjury charge for once. It's not every day you see that. And now the statement of fact. So background here. And all of this is important because, again, there's no physical evidence putting Andrew Hayes there. Danny Harris's badly beaten and decomposing body was discovered in late October of 2007, sparking an investigation into his death. Mr. Harris, he wore a pacemaker. Those pacemaker records eventually revealed that he died on August 20th, 2007 at 10:36 a.m. Memphis Police Department arrested Tammy Vance, Mr. Harris's prior living girlfriend, on October 31st, 2007, when they received a tip that she was driving Mr. Harris's stolen truck around town. So she was driving his Silverado around town, and on Halloween, they end up, like, the cops, MPD, stops her, or they pull up around her if she was already parked at a Mapco gas station, start questioning her, and ultimately decide to take her in. Tammy Vance and her adult daughter, Sarah Lucas, both initially denied any involvement in the murder and insisted they thought Mr. Harris was in rehab for his alcoholism. Even when police later confronted Sarah Lucas with proof that she'd been pawning Mr. Harris's stolen property at local pawn shops, so daughter is pawning Mr. Harris's belongings, but Sarah maintains her story anyway. MPD did not investigate or question Sarah Lucas any further. However, they charged Tammy Vance with the murder of Danny Harris. Andrew Hayes was not originally a suspect in the case, but through a series of events, we'll find out, we'll go to this, oh, cool, it jumped us to the footnote. This footnote says that on November 1st, Andrew Hayes was at 201 Poplar to give his girlfriend, Shawana Jefferson, and her mother, Janice Snow Jefferson, a ride home. So this is where we have the jail and the police station. He goes there. Shawana and Janice were going in to give a statement. They were going to talk to the police, and he had followed behind them in a different vehicle to give them a ride home when they were done. So they were being interviewed because Tammy Vance and Sarah Lucas had rented a room in Snow. We're going to call it Snow's house, in September of 2007. So they end up moving into this house right after the murder. Like, well, we can't live in Danny's house anymore. So they find this apartment. It happens to be owned by Andrew's girlfriend's mom. And they end up leaving some property behind that belonged to Danny Harris. So Shawana Jefferson and Janice Snow Jefferson want to tell the police, like, hey, we think this is sus. At the police station, Mr. Hayes, so Andrew, strikes up a conversation with an officer while he was in the hallway watching his son. MPD realized that Andrew Hayes also knew Sarah Lucas and Tammy Vance from their time at the Jefferson home, and so MPD decided to bring him back for an interview. So that's how they're suddenly interrogating Andrew Hayes. So this is on November 2nd, 2007. MPD brings Andrew Hayes to 201 Poplar and began an interrogation that lasted nearly 27 hours, during which he gave multiple conflicting statements. During the lengthy interrogation, Mr. Hayes was kept isolated, shuffled around to various rooms within 201 Poplar, interrogated by multiple officers, shown photographs of the crime scene, which is a crucial detail, because part of the denials that we've seen along the way to get where we are today have been, well, Sergeant Mullins went in there, and when they were ready to get this formal confession, formal statement with the transcriptionist, even though Mr. Hayes is getting details wrong, Mullins goes back in and talks with him again, and then he gets another chance to give a formal statement. And then the details are details only Andrew Hayes could have known if he was there and has personal knowledge of what was going on. But Sergeant Mullins he said that he did the bloodstain pattern analysis at the crime scene. And he had crime scene photos. So he was at the scene himself. He looked at all the blood. He had photos of this stuff. And he talked with Andrew Hayes for hours right before they tried to get that first formal statement with the transcriptionist. And he's messing up details. Andrew's messing up details. So then he goes and talks to him again. But the theory, the denial of some of these initiatives, and also presented at trial, was that his confession was credible because he gave details about the crime scene. So thus, he must have been there. That's the only way he could have known about certain details about the crime scene and what happened to Danny Harris. So, critical detail here. Critical detail. So, and then they say, and he was fed facts of the crime. Mr. Hayes was told by officers that the only way he could go home was to tell them the, quote, truth about how Mr. Harris, a man whom Mr. Hayes had never met, was killed. Mr. Hayes blamed numerous innocent people for the crime and broke down so completely that the interrogation had to be paused, while Mr. Hayes was sent to an isolated jail cell, only to be resumed in the early morning hours of November 3rd, 2007. As a result of the coercive interrogation, Mr. Hayes, who has an IQ of 62, signed a statement confessing, with air quotes, to hitting Mr. Harris in the back of the head with an iron pipe on the second floor of his apartment 2 weeks prior. Despite the fact that the crime had taken place nearly 2 months prior, in a one-story apartment, no upstairs, and there were no injuries to the back of the victim's head, Mr. Hayes was arrested and charged with murder. So after 27 hours, they get a confession that doesn't even make sense, and they arrest him anyway. Prior to Mr. Hayes' trial, his co-defendant Tammy Vance amended her statement to include Mr. Hayes as a participant in the crime and then voluntarily took a plea for a life sentence. So her initial statement did not include Mr. Hayes as a participant. She amends it and then gets a life sentence. However, when an investigator for the defense subsequently interviewed Tammy Vance, she admitted that Mr. Hayes was not involved in the murder. She explained that she implicated him in her statement only because officers told her he had confessed and because she was trying to protect her daughter, Sarah Lucas, who had been involved. Ms. Vance attempted to stop the prosecution of Mr. Hayes, and when the state moved forward with the charges against him, Ms. Vance agreed to testify at Mr. Hayes' trial. Andrew Hayes went to trial in 2010, where 2 competing theories about the death of Danny Harris were presented to the jury. The state's theory was that Mr. Hayes and Ms. Vance killed Mr. Harris in a robbery gone bad. This theory relied on Mr. Hayes' confession and on an MPD officer who claimed that the crime scene corroborated the confession based on his analysis of the blood spatter. The defense's theory was that Sarah Lucas and Ms. Vance killed Mr. Harris. Ms. Vance testified that Sarah Lucas killed Mr. Harris with a hammer the morning of August 20th, 2007, after the 3 of them returned from Arkansas, where Sarah Lucas was issued a state ID. And this is important here. This license showing the issuance date was introduced, but no other physical evidence was introduced to corroborate Ms. Vance's testimony. Sarah Lucas strongly denied her mother's version of events, and because no other corroborative evidence was introduced to verify Ms. Vance's testimony, the jury convicted Andrew Hayes, and he was sentenced to life. So this evidence here that wasn't presented deals with, like, cell phone locations. And Sarah Lucas claimed that she was dropped off, so she couldn't have been there, but that's not what the cell phone records show. But the jury didn't get to see it. Mr. Hayes has been fighting to prove his innocence for 18 years. So here we get to new evidence of actual innocence. So this is my first time reading Sarah Lucas's words. Now we see Stephen Harris on the page. This is a relative of the victim, Danny Harris. So this transcript part here reads, Sarah Lucas, I didn't hit him with a hammer, my mom did. Stephen Harris says, it was just you and her, correct? Sarah says, yes. Stephen Harris says, Andrew was never there. Sarah Lucas says, no. So this is a conversation date marked as being from late 2025. In the past few months, new evidence has come to light that definitively proves Andrew Hayes' innocence. The new evidence is Sarah Lucas, in her own words, describing the morning of Danny Harris's death. Her statements prove that all her prior testimony was untruthful and that Mr. Hayes had absolutely no involvement in the murder of Danny Harris. Sarah Lucas admitted that only she and her mother were in Danny Harris's apartment the morning of August 20th, 2007, that she saw her mother hit Danny Harris repeatedly with a hammer, that she helped her mother by holding him down during the attack with a pillow, that she vomited on the bathroom floor, that she and her mother attempted to clean up the crime scene, that she knows Andrew Hayes is innocent, and that she has no intention of sharing what she knows because she fears legal consequences. The new evidence comes in the form of recordings of conversations between Sarah Lucas and one of Danny Harris's sons, Stephen Harris. Stephen Harris, after hearing the oral argument in Mr. Hayes' appeal, so those oral arguments that I mentioned on this but we watched yesterday, from August 5th of 2025, decided to independently investigate his father's murder by building a friendship with Sarah Lucas. He gained her trust over a period of weeks, spending hours on the phone with her, and she eventually revealed critical information of Andrew Hayes' innocence. Stephen Harris recorded all of their conversations and has provided defense counsel with 3 recorded phone conversations. In the first recorded call, Sarah Lucas maintained her charade of non-involvement, but made statements that contradicted her trial testimony. In the second recorded call, Sarah Lucas finally admitted the truth, that she and her mother murdered Danny Harris and that Andrew Hayes was not involved. In the third recorded call, Sarah Lucas explained that she will not come forward with the truth, even though an innocent man is in prison, because she fears facing her own legal consequences. So here's Exhibit R, recording of Stephen Harris and Sarah Lucas. So I guess this would be the second call. Do they say right here? Let's see. Yeah, so this is the second recorded call that was provided to defense by Stephen. So in this recorded call, Sarah Lucas confessed that she assisted her mother in killing Danny Harris and that Andrew Hayes was never involved. So Sarah says, I didn't hit him with a hammer, my mom did. Stephen says, it was just you and her, correct? Sarah, yes. Stephen, Andrew was never there. Sarah, no. Stephen says, God damn it, Sarah. And then there's an ellipses, and it looks like you could see a longer pause here. Then Stephen says again, tell me what happened. Exactly what happened. Just don't lie to me. Sarah, okay, my mom and him were arguing. Stephen, over what? Sarah, over beer. She was always mad at him for drinking. Stephen, so you all got back from West Memphis. Walk me through everything. I want to know everything so I'm not missing out on anything, and I want to know everything. That's all I've asked from you. Sarah, okay, we got back from West Memphis. They were still arguing. He sat down in the chair. She went in the room. He got up, went into the room. My mom came out and said they were going to sit there for a little bit and talk. I said, okay, I'll be out here. I didn't get in their business like that. Well, next thing I know, she hollers for me, and I go in there, and she's hitting him in the face with a hammer. Stephen, did you hold the pillow over his face? Yes or no? Tell the fucking truth. Sarah, the pillow over his face? I don't know. I might have. That part, I mean, I don't remember a lot, I'm not gonna lie. Stephen, you helped her out, correct? Sarah, I helped her a little bit by, I think, holding something, but it might have been a pillow. Stephen, are you the one that put the rag in his mouth? Yes? Sarah says, no, I didn't put a rag in his mouth. She did that. She's the one that poured bleach, and the transcription says they're both speaking at once, and rag. Stephen, she what? Sarah, bleach and a rag. Stephen, she poured bleach on a rag? Sarah, bleach on him and a rag. Stephen, so you held a pillow over his face, correct? Sarah, I might have, yeah. Then they're both speaking at once. Stephen says, okay, and you hit him once? Sarah says, I didn't hit him with a hammer or nothing, no. Stephen, so she hit him one time and you ran in there while they were scrambling and you helped hold him down, correct? Sarah says, yeah. Stephen says, that's what I thought. Why did, I mean, just between you and I, because I'm not opening this can of worms with nobody else, obviously. How did fucking goofball get tied up in this shit? Is he that dumb? Sarah, they're both speaking at once, that part either, maybe understood. I think Tammy put him in all of this, if I'm not mistaken. Well, so my theory, let me step back from this transcription for a second. We heard that during this process, when Tammy is being questioned in a room right next to Andrew Hayes, because Tammy says that she can hear him like screaming, crying, like he's upset. They're next to each other in these rooms. And MPD, the Memphis Police Department, they're both telling the others that so-and-so put you in it, so-and-so put you in it. So I would say that originated with MPD. And then Stephen goes on to say, so when did Tammy get the black eye? Sarah says, I guess he hit her in there. She did something to him and he hit her. Stephen, why was it a hammer? Sarah, I don't know, but that's what she used. That part she never told me. Like I said, I never knew why Tammy did the shit she did. Stephen, yeah, well, I mean, what made you attack him too? I mean, because she was fighting with him? They're both speaking at once. Sarah says, I mean, she would do things, and I was just trying to do what she said. Like what? Like, I guess the pillow or whatever, but I didn't attack him. Then they're both speaking again, and Stephen says, say again? Sarah says, I hated my mom after this. Stephen, I mean, you helped hold him down. I mean, you helped. Essentially, y'all two are the ones that fucking killed him. Oh, sorry, essentially. And then Sarah said, I didn't kill him like that. Or, I wonder how she says this. I didn't kill him like that. Awkward. Stephen says, Sarah, you helped out. You held him down. You held a pillow on him while she's beating him. So, yes, you essentially did. There's no point of saying. And then both speak at once. And then Sarah says, I never looked at it like that. I'm sorry, I don't. Stephen says, you don't think that's accessory to murder? I mean, that's exactly what y'all did. But like I said, you're lucky. So Sarah says, I hate her for this. You have no clue. Even though she's dead and gone, I hate her for everything she's done. Stephen says, well, Sarah, you need to take a look in the mirror too because you're part of this. You know what I mean? And then there's a pause. Kind of a long one. Stephen says, all right, so let me ask you this. This has been bugging me too because I know how his pacemaker, went off at 10:05. I guess it is when they started fighting. Was he knocked out and then y'all started doing stuff and then he started moaning and talking and coming back? Sarah said, no, he never said anything. Stephen, like he didn't scream for help or anything like that? Sarah, no. Stephen, all right, tell me, so she hit him. How many times are we talking? Sarah Lucas says, I don't know. It was a lot that she hit him. Stephen, just with a hammer? It was only a hammer? Yep. And then did you see her put the rag in his mouth? I think I did, yeah. Stephen, when did the bleach come in hand? Sarah, I guess after she did it. I just know she poured it. I don't really remember. It was a big blur for me. Stephen, I assume you and her both were covered in blood? Sarah, no, I didn't really have anything on me. And Stephen said, you had some. Sarah said, probably some, yeah, but I mean, I didn't see a lot. Stephen, what did y'all take that moment when y'all left? Sarah, we didn't take anything. Nothing taken except maybe a wallet and stuff like that, but nothing else. Stephen, and the truck. Sarah, she took the truck, yeah. Stephen, yeah, so y'all came back over there and got the other stuff later. Sarah, I've never had a driver's license, so I couldn't take the truck. Stephen, yeah, I know, but y'all came back over there afterwards numerous times and got more stuff, correct? Sarah, I didn't go back over there. She did. And then there's like a pause for a while. That's like a 2-minute pause almost. Sarah says, I swear on mine and my daughter's life, I don't remember that part. I was scared to death. So I wonder what was cut out of this. I want to read it. I want to hear it. And then Stephen says, okay, Andrew was never there when this happened. What a retard. That's a long, long sentence. Sarah says, are you mad at me? Stephen, yeah, I'm quite mad, but I told you I'd keep my word. Sarah's daughter begins speaking in the background. You hear that voice in the background? That's your lucky second chance. I really hope you don't fucking blow it and do something stupid down the road. Sarah says, I'm not. I'm working on my life, I promise. Stephen Harris, I wish you would take a little bit more accountability that, that y'all both hit him. That would be my final thing. Sarah says, I'm being honest with you on mine and her life. I don't remember that part. Stephen, you saw your mom actually hit him first, correct? Sarah says, yes. Stephen, were you in the bedroom when she hit him? Sarah, no, I ran in the house because I heard the commotion. Stephen, so after the first blow, was he already on the bed or was he fighting back? Sarah, I think that's when he hit her. That's what I think. I didn't see it, but that's what I think. I could be wrong, but I don't know that for sure. Stephen, Andrew Hayes did not even fucking know my dad or never did this, and oh, what a knucklehead he is. Sarah, are you going to go to the police with it? Stephen, no, and I don't expect you to either. No point in opening this up. I got what I wanted. I know the truth, most of it. That's all I ever wanted was to know exactly what happened. Sarah, I don't even know why my mom did it. Did what she did, hit him. I don't know why. Stephen, well, you could have stopped her. You know that. Sarah, I was trying. And they're both speaking at once. Stephen says, you were holding him down, helping her. We just talked about that. Like, what? Sarah says, it would have been afterwards. It wasn't in the middle of it. I was freaking the fuck out telling her to stop, stop, stop. that all she would have gotten was a little bit of jail time for hitting someone. Stop. Stephen says, okay, but you held a pillow over his face, Sarah. Then there's an ellipses again. Stephen says, well, I think you did hit him with a hammer. I feel like that's 100% accurate. I think y'all both did. I think y'all both were holding him down. One was doing one thing. I think you were hitting him on the head with a hammer. Sarah, I don't remember hitting him in the head. I didn't. My mom was the one with the hammer. I never was. I never had the hammer. Stephen, and you didn't pour the bleach on him? Sarah, no. I probably put it in the sink or something, but I didn't pour it on him. Stephen says, and there's a gap here, I wonder why Tammy'd get so mad at you after the fact and then turn around and say you did it. Sarah, because I couldn't give her money. So that is the end of this transcript here for Exhibit R, which was the second call of the 3 turned over to the defense. Man. And I'm still not sure. I don't know if Stephen... So Danny Harris had multiple sons, and one of the sons is law enforcement, worked at the sheriff's office. So I'm not sure if that son is Stephen, and that's why, you know, maybe he has more experience getting information out of people. But it's still extremely interesting. I think it's so interesting to see this is someone that heard the oral arguments in August, and then by, you know, September, they're trying to build rapport with Sarah, and then between then and the end of 2025, they end up getting these recorded calls where Sarah's like, yeah, I held him down at least. Well, I think you did more than that. Yeah, it was all a blur, but okay, I did some of it. Very, very interesting to be able to see this. So Exhibit S, which would be the third recording of Stephen Harris and Sarah Lucas. Stephen Harris referenced their prior conversation where Sarah Lucas admitted that Andrew Hayes was not involved in Danny Harris's murder, and he asked Sarah Lucas whether they should care that Andrew Hayes was in prison. In other words, should they feel any guilt that an innocent man is in prison for a murder he did not commit? So Stephen says, just between you and I here, because I've been mulling with this and trying to get my head around this, trying to figure out how to process this. Should we care that this guy is in prison and never did anything, or should we just let it be? Sarah, well, he's done a lot of other stuff. Stephen, like what? Sarah, well, he was doing drugs. He beating on his girlfriend. He never went to jail for none of that. There's a footnote here. These are unsubstantiated allegations. Andrew Hayes has no criminal record. So Sarah's, for all we know, Sarah's just saying that. Sarah Lucas asked Stephen Harris what she should say during her upcoming interview. Stephen Harris cautioned her to just tell the truth. So let's see this. Footnote 5 says Stephen Harris lied to Sarah Lucas and told her that a woman wanted to interview her for a book about the death of Danny Harris. Oh, man. Go ahead, Stephen. Find out what happened. Sarah Lucas asked Stephen Harris what she should say during her upcoming interview. So Sarah's of the belief that somebody wants to do some book deal. Stephen Harris cautioned her to just tell the truth. Sarah Lucas, tell her the truth? What do you mean? That I was there? Stephen, I mean, if you did that, you could probably sell a lot more books. But... Sarah, I don't want to tell her I was there. Stephen, I mean, I getcha, but I don't know. Dude, this is your side of the story you got to tell. Sarah, I don't want to tell her I was there because she could go to the police at that. Sarah Lucas continued to share her personal memories from the morning of Danny Harris's death. Finally, Sarah Lucas shared that she got sick in the apartment after Danny Harris's death. Sarah described having to clean it up because she did not make it to the toilet, explaining why a bathroom rug and rag were found in the washing machine. Stephen, did you get sick that day while you were there? Sarah, yeah. Stephen, where'd you throw up? Sarah, in the toilet and cleaned it up. They're both speaking at once. In front of the toilet too because I didn't make it fast enough. Stephen, was it on the bath rug? Sarah, it might have been. Stephen, yeah, that's why y'all was washing in the washing machine the bath rug. Sarah says yeah. The new evidence establishes that Sarah Lucas lied to investigators about her involvement in Danny Harris's murder. Sarah Lucas admitted to being present in the apartment the morning that Danny Harris was killed. She admitted to seeing him murdered with a hammer. She admitted to assisting her mother by holding Danny Harris down. She admitted to getting sick in front of the toilet. She admitted that Andrew Hayes was not involved. Then there's additional exculpatory evidence. And before we get into this, so Tammy's story was a little bit different. Tammy's story was Sarah gets upset because on this trip back from getting this ID, Sarah's hungry. And they've all been tight on money. Danny was apparently thinking about declaring bankruptcy. His SSI checks weren't enough. But on the way home on this trip, where it's Tammy, Sarah, and Danny all together, Sarah's hungry. So they stop at a Burger King. They get some food just for Sarah. And then when they go home, Tammy fixes up, like, I forget what she said, but maybe like an egg sandwich or something like that for herself and for Danny. So they spend a little bit of money because Sarah wants fast food. They spend that money. Tammy ends up saying, keep the change to the employee working at the drive-thru. And apparently Danny, like, starts simmering on that and is upset about that because there's financial issues. Going to Burger King is a luxury, and they're obviously eating food that they have at home for themselves, but they're treating Sarah, and then they're giving the leftover change to the cashier. So apparently when they get home and Tammy's cooking breakfast, this, like, blows up. This fight about money and finances. It blows up into a fight. And Danny Harris, the victim, apparently hits Tammy. And Sarah sees that. Sarah's not outside. This conflicts with what Sarah's saying. Oh, I was just sitting outside. I didn't get into their business. Tammy's version of events is that Sarah saw Danny hit her mom, Tammy, was upset about that, and Tammy's doing whatever, hears a commotion and goes in, and Sarah's the one actually hitting Danny Harris. And that Danny's being hit by Sarah because Sarah's upset what Danny just did to her mom. So then Tammy tries to protect her daughter, tries to help clean up, and then obviously takes the fall, takes a plea to life to protect her daughter so her daughter doesn't actually get charged and sit on trial. So, I don't know. I guess either are possible, and both stories do not involve Andrew Hayes either way. So, there we go. But that's the difference in the story. And obviously, Tammy was already serving a life sentence. Her help was failing. So, I feel like her saying her version of events, I have less reason to doubt it. But Sarah, at this time, was still trying to keep herself out of dealing with any legal repercussions for this. So there would be a better reason, in my opinion, for Sarah to be like, it was a blur to me. I was just outside. I walked in on it. It was my mom doing it, and I just helped with some bleach or whatever. But moving on from that, we've got additional exculpatory evidence. So additional exculpatory evidence exists that fully corroborates the information in the recordings and, by extension, proves Andrew Hayes' innocence. The majority, and this is critical, the majority of this information has yet to be put in front of a jury. So we've got cell tower data from the morning of Danny Harris's death. Verifies that Tammy Vance, Sarah Lucas, and Mr. Harris spent the morning together and were at his apartment at the time of his death. Tower data mapped the phone in several locations that morning, tracking the trio's location from Mr. Harris's apartment to Miss Lucas's apartment to West Memphis, Arkansas, where, again, this is where they end up getting the ID card for Sarah, and then back to Mr. Harris's apartment by 9 a.m. Mr. Harris was killed an hour and a half later. Sarah Lucas admitted these facts in the recording and confirmed that the murder happened after the three of them got back from West Memphis on the morning of August 20th, 2007. Mr. Harris's phone records on the day of the murder implicate Miss Lucas and Miss Vance, as they show substantial communication from Mr. Harris's cell phone in the minutes after his death to people in the Lucas and Vance family. So after the pacemaker is done, there's no more pacemaker readings, we suddenly have phone activity on Danny's phone, who we can conclude is no longer alive. And those calls are all going to people that Sarah and Tammy know. They're not going to anyone in the Hayes family or to Andrew Hayes' girlfriend or anything like that. His cellular activity is going to people that would be connected with Tammy and Sarah. So specifically, mere minutes after his death, someone used Mr. Harris's cell phone to call Heather Balderas. Heather is critical. Heather is That's where the letters were found, but she's no longer alive. She would be an unavailable witness at a trial for Sarah or a retrial for Andrew. That's Miss Vance's other daughter and Miss Lucas's sister, repeatedly. So whoever had the cell phone talked to Miss Balderas for several minutes from the crime scene. Pawn shop records demonstrate that Sarah Lucas was pawning Danny Harris's stolen property just 4 days after his death. Close to $3,000 was stolen from Danny Harris's bank account through the fraudulent use of his ATM card and through the cashing of forged checks. Memphis Police Department failed to obtain more than one surveillance videotape of the ATM card being used, but this singular surveillance tape shows Miss Vance using the card. Moreover, Miss Lucas's fingerprint was found on at least one stolen check recovered from Mr. Harris's stolen truck. In 2008, Miss Vance wrote a private letter to Miss Lucas from prison. In the letter, Miss Vance asked Miss Lucas for money and reminded Miss Lucas that she protected her from ever going to jail or prison and let an innocent man take her place. So I would imagine we heard Sarah mention this in Exhibit R, the second phone recording. And I wonder if this stood out to her because she was thinking, shit, they monitor these letters. And now my mom's writing something like, I protected you from even going to jail or prison and let an innocent man take her place. So if anybody's monitoring these letters, Sarah's going to be pissed because this letter inculpates Sarah. So to me, this makes sense. This came through a jail letter. And it seems like Sarah's stuck on it because she mentions it in that recorded call with Stephen. Sarah Lucas acknowledged the financial arrangement in the recording and confirmed that her mother stopped protecting her when Miss Lucas stopped putting money on her books. Numerous family members of Miss Lucas were interviewed, and they signed affidavits describing the open secret in their family that Miss Lucas and Miss Vance were responsible for the murder of a man in Tennessee, and that Miss Vance took the fall for both of them. The family members know specifics about the murder, such as the fact that a hammer was used, that the women returned to the apartment after the crime to steal his television and checks, and that they lowered the AC in the apartment and poured chemicals on the body to cover the smell. That Miss Vance wrote numerous letters over the years to Miss Lucas about the crime, and that when Miss Lucas was confronted about the possibility of the case being reopened, rather than deny involvement, Miss Lucas stated, "They won't find me." Previously unexplained evidence from the crime scene is resolved by Miss Lucas's explanation of the aftermath of the murder. She confessed to getting sick in the bathroom, not making it in time to the toilet, and having to clean up the area in front of the bathroom toilet. A cleaning rag and the bathroom rug were found by crime scene detectives in the washing machine, providing an independent verification of Miss Lucas's statements. So right here, this little bit that we get from the recording corroborates more about the crime scene information and actually fills in some gaps. Meanwhile, the confession that they used to arrest Andrew Hayes contradicted the crime scene. He's talking about the second story, but it's a one-story apartment. He's talking about 2 weeks ago, but Danny Harris has been dead for 2 months. And here we are already, Sarah, with this little bit of detail. It matches more with what was actually happening at the scene. The medical examiner's report also verifies Miss Lucas's confession to holding a pillow over Mr. Harris's face during the murder. The report lists 2 causes of death: blunt force trauma and asphyxiation. In short, a plethora of evidence exists that supports Sarah Lucas's recording confessions. None of this evidence has ever implicated Andrew Hayes. Instead, it all definitively points to Miss Lucas and Miss Vance. So the legal argument. So why are we here once again with this error coram nobis? So the objective of an error coram nobis petition is to remedy a significant, undeniable justice within our evolving system of criminal justice. In Stay v. Mixon, the Tennessee Supreme Court highlighted the importance of adopting this extraordinary remedy. To summarize and borrow from a statement made by the Florida Supreme Court when urged to adopt a similar rule, if rules of procedure have become so inflexible that courts are unable to provide timely relief to an innocent person wrongly convicted, then we have lost the creative faculty that we have always thought to be resident in the judiciary. I love it. Then they go to the Tennessee Code Annotated. Section 40-26-105 provides the operative standards for providing the remedy of writ of error coram nobis. So the writ is reserved for cases in which there is newly discovered evidence that relates to matters litigated at trial. 2, the defendant shows he was without fault in failing to present the evidence at the proper time. Obviously, Andrew Hayes would not have been in possession of conversations, recordings that happened in 2025. And then 3, the trial judge finds that presenting the evidence at trial may have resulted in a different judgment. Well, I would sure hope so, but man, juries scare me. The jury verdict in the trial here kind of scares me. I feel like the jury got it wrong based on what was presented, even though there's issues with things that weren't presented. So, a petition for writ of Coram Nobis must allege newly discovered evidence with sufficient specificity to establish a claim for relief. When such allegations are adequately pled and supported by the record, the writ serves to remedy convictions that would not have occurred had the new evidence been known at trial. Accordingly, a petitioner who satisfies this burden is entitled to have their conviction set aside and a new trial granted. Mr. Hayes' conviction is an injustice that necessitates the extraordinary remedy of Coram Nobis relief. So, first here, due process requires tolling of the statute of limitations. So they're going to say that this is, in fact, newly discovered innocence, and that this newly discovered evidence actually establishes his innocence. So while typically a petition for writ of Coram Nobis must show on its face that it is timely filed within 1 year of the final judgment, Tennessee Supreme Court has recognized that due process requires the tolling of the statute of limitations in certain cases where a petitioner would otherwise be denied the opportunity to present meaningful claims. They give a ton of case law. In 2024, the Tennessee Supreme Court provided guidance for tolling the statute of limitations in Clardy. In Clardy, the court distinguished a merits analysis from a tolling analysis, explaining that the analysis for relief on the merits of the petition is separate and distinct from the analysis of whether the statute of limitations may be tolled. So building on this distinction, the court further clarified the standard of proof that must be met when a petitioner is seeking equitable tolling of the statute of limitations. So that holding, if a petition for a writ of Coram Nobis is not timely filed and seeks tolling, it must be based on new evidence discovered after expiration of that 1 year period. And it must clearly and convincingly, so that's the standard, it must clearly and convincingly show that the petitioner is actually innocent of the underlying crime. In other words, that the petitioner did not commit the crime. And I would say a confession from the daughter of somebody else who took a plea already and confessed, who together were both pawning objects. Pretty good showing of actual innocence for Andrew Hayes. And that the petitioner did not commit the crime. To obtain tolling of the Coram Nobis statute of limitations, the prisoner must file the petition no more than 1 year after he discovers the new evidence of actual innocence. So whenever they get these recordings from Stephen Harris, that would restart the timing for the statute of limitations to kick in. And obviously, if they got these recordings, let's say December 2025, they filed this on January 6th, they're well within the 1 year period. So in short, the Clardy court instructed lower courts to evaluate a Coram Nobis petition using the following analysis. 1, determine whether the evidence in the petition is new and was not available to the petitioner at the time of trial. 2, determine whether the new evidence was filed within a year of its discovery. And 3, determine whether, if credited, the evidence would show by clear and convincing evidence that the petitioner did not commit the crime he was convicted of. So Mr. Hayes was convicted and sentenced in 2010, so obviously it's beyond the statute of limitations, but under Clardy, with this new evidence, we can start the tolling again. We got equitable tolling here. So Sarah Lucas was asked about her involvement in the murder of Danny Harris at trial. At that point, she denied any involvement in his death. So 2010 is a totally different picture than what we're seeing in 2025 with these conversations. She denied being with him the morning of his murder. She denied having any knowledge about the circumstances of his death. Sarah Lucas did not tell the truth at trial. Because she hid the truth from the jury, the information she knew was not available to Mr. Hayes at the time of this trial. In Hayes, the Court of Criminal Appeals concluded that the presented evidence of family member affidavits that suggested that Sarah Lucas was involved in the crime was not newly discovered because Tammy's testimony revealed the same facts as those contained in the affidavits, and otherwise provided no new information that existed at the time of trial, and provided no information that fundamentally strengthened Mr. Hayes' defense. So this is the decision that resulted from the oral arguments that we watched. Here, however, the information Sarah Lucas shared with Stephen Harris is simultaneously a never-before-heard confession to murder, a declaration of Andrew Hayes' innocence, and a cache of new information about the morning of Danny Harris's death. Sarah Lucas's statements are a direct confession to her participation in the murder, something the jury never heard her admit to. And again, even that little detail about the vomit and washing the bath rugs, and knowing that there was, from the crime scene evidence, maybe the photos, that they knew that this rug and a rag were in the washing machine. This is something entirely new that has never been addressed before. Sarah Lucas's statements about holding a pillow over Mr. Harris during the struggle explains the death of asphyxia, something the facts at trial previously attributed to a rag stuck in his throat. Sarah Lucas is clear in the recordings that Mr. Hayes was never involved, information the jury previously only heard Ms. Vance testify to and never heard corroborative proof of. Sarah Lucas admitted to being with her mother and Mr. Harris the morning of his death, admitted to hearing the two break out in argument, admitted to seeing Miss Vance hit Mr. Harris repeatedly with the hammer, admitted to helping her mother in the struggle by holding Mr. Harris down, and admitted to getting sick in the bathroom. All information the jury never heard anyone admit to, and instead heard Sarah Lucas directly deny. So not only is this information newly discovered, but it goes far beyond fundamentally strengthening Mr. Hayes' defense. The information establishes his innocence. Thus, the evidence in this petition is new for the purposes of a Coram Nobis tolling. And then they're going to say it was timely filed, so they're going to say Stephen Harris recorded his phone conversations with Sarah Lucas in a period of time between August 2025 and November 2025. So we're not even a year from that mark, and obviously this could not have been produced to the defense before these conversations took place. And then 3, assuming its truth, the newly discovered evidence establishes Mr. Hayes' actual innocence by clear and convincing proof. To toll the statute of limitations, Clardy directs courts to assume the newly discovered evidence is credible, and then ask the court to, assuming the credibility of the new evidence, evaluate whether it clearly and convincingly demonstrates the petitioner is actually innocent. And I would hope we do not have some type of ruling from this court that says, nope, we don't think this demonstrates actual innocence. So again, District Attorney Steve Mulroy says he's not going to fight any efforts from Hayes' team. He has declared, he stated that he thinks Andrew Hayes is innocent. And again, he made the charging decision for Sarah Lucas. But again, I don't want to see anything dumb in whatever this court, their response, their opinion for this error Coram Nobis. And I don't even know if the state is going to file something opposing it, because why would DA Mulroy allow his office to do that? So if the court was going to be funny about this, they'd be doing it on their own without the state raising an argument. So while I think there's a really good chance that this error Coram Nobis petition is going to be granted, I just feel like I'm so pessimistic. I feel like I'm so but I don't know. Because we've just watched time after time after time all of his other efforts get denied. So I'm way more optimistic than I usually am, but there's still a piece where I'm like, I'll wait and see. Based on the guidance provided by the Clardy Court, Mr. Hayes has met his burden. If taken as true, Sarah Lucas's recording statements establish that she was a participant in Danny Harris's murder. Her confession establishes that she was with Danny Harris and her mother the morning of August 20th, 2007, that she saw her mother hit Danny with a hammer, that she assisted her mother by holding Mr. Harris down, and that she saw her mother pour bleach on a rag and onto Mr. Harris's body, and that she vomited on the floor of the bathroom and had to clean it up. Sarah Lucas admitted that Andrew Hayes was not in the apartment. He did not kill Danny Harris. If it is true that Mr. Hayes was not present in the apartment when Mr. Harris was killed, he has established his innocence. In sum here, the new evidence excludes Mr. Hayes from involvement in the crime. 1, it's proof that Mr. Hayes was not involved in Mr. Harris's murder. 2, it's proof that Sarah Lucas participated in the crimes against Mr. Harris. 3, it is proof that Sarah Lucas lied to the jury about her own involvement in the crime and about her knowledge that Mr. Hayes was innocent. And 4, it is proof that Mr. Hayes' confession was false. Taken as true, the newly discovered evidence establishes Mr. Hayes' innocence by clear and convincing. And I see that I missed a footnote. I guess up here. So I missed a footnote at the beginning of the page where we're still talking about the Clardy. So let's read this long footnote. So Mr. Hayes' case is distinguishable from Clardy, where the court ruled that the petitioner did not meet the standard to toll the statute of limitations. Petitioner Thomas Clardy's case centered around the question of whether he was involved in a shooting. The accusation at Clardy's original trial was that 3 men had driven after hours to the workplace of brothers Kirk and Kent Clocher, shooting and killing Kirk. A surviving witness later identified Clardy as the shooter, and Clardy was convicted based on the identification. In post-conviction litigation, ballistic evidence was discovered that matched the spent bullets at the crime scene to a gun connected to cousins of D'Antoine and Thomas Collier. The subsequent Coram Nobis petition that led to the Clardy decision featured a singular affidavit by D'Antoine Collier asserting that he had never met Thomas Clardy, nor received any property from him. In response, the Clardy court reasoned, as noted in the post-conviction proceedings, the ballistics evidence did not show Clardy was not in possession of the firearm when the underlying crime was committed. The D'Antoine Collier affidavit did not change that. The Clardy court adopted the reasoning of the trial court to conclude that the affidavit did not rule out or even seriously undermine Clardy's involvement in the underlying crime, and as such, would not, if credited, clearly and convincingly show Clardy is actually innocent of the crime. So yikes. They're like, well, the new ballistics and D'Antoine saying he's never met the guy don't rule out that it wasn't Clardy, and it seems like all we have is an eyewitness identification identifying Clardy as the shooter. So, kind of wonder what happened in that case. And let's read this full sentence where we left off. So, taken as true, the newly discovered evidence establishes Mr. Hayes' innocence by clear and convincing evidence. As such, he's entitled to tolling of the 1-year statute of limitations and should be granted a hearing to evaluate the new evidence and its application to the writ of error Coram Nobis statute. Frankly, if this evidence of a witness confessing that they lied to the jury, that they participated in a murder, that they were involved in the cleaning up and cover-up of the crime, and that the accused was not involved, does not satisfy the requirements of Clardy, it is doubtful that any other evidence could. Yeah. I mean, this is a nice little paragraph here. You know, I haven't done one of these yet. Gotta work one of these in. I think this is a good time. They're cooking with this paragraph here. The newly discovered evidence satisfies the requirements of section 40-26-105 because it is new, it's admissible, and it's credible. As such, Mr. Hayes is entitled to relief on the merits of the statute. So this is a standard set forth in our Coram Nobis statute. The relief obtainable by this proceeding shall be confined to errors de hors of the record, and to matters that were not or could not have been litigated on the trial of the case, on a motion for a new trial, on appeal in the nature of a writ of error, on writ of error, or in a habeas corpus proceeding. Upon a showing of the defendant that the defendant was without fault in presenting the evidence, failing to present certain evidence at the proper time, a writ of error Coram Nobis will lie, and they're emphasizing this, will lie for subsequently or newly discovered evidence relating to matters which were litigated at the trial if the judge determines that such evidence may have resulted in a different judgment, had it been presented at the trial. The Tennessee Supreme Court defines newly discovered evidence as evidence that is A, of facts existing but not yet ascertained at the time of the original trial. So a great example of that would again be the pillow for the asphyxiation, or the rugs that were found in the rug that was found in the washing machine. They must be admissible, and they must be credible. The newly discovered evidence presented in this petition satisfies each of these requirements. As such, Mr. Hayes is entitled to relief under the Coram Nobis statute. So, to draw a parallel over to the Jason Autry recanting over in the Zachary Adams trial, we had the state file several filings concerned about Jason Autry, the credibility of his statement. And they said, well, he was on drugs when he was talking to Dr. Katie Spirko, that he was just trying to get back at the state, and that he had just signed, as part of sentencing proceedings in another matter, he just signed off under penalty of perjury on a different version relating to the testimony he gave at the 2017 trial against Zachary Adams. So the state in the Zachary Adams case fought on the point that somebody's confession was credible, raising those different grounds, right? So the state pushed back in the Zachary Adams error quorum nobis petition against this prong. So here, I imagine we're not going to see Mulroy's office push back. Next, we have here the facts existed, but were not ascertained by Mr. Harris at the time of trial. In the realm of Coram Nobis jurisprudence, evidence of facts existing, but not yet ascertained at the time of the original trial, refers to evidence that existed at the time of trial, but of which the defendant, through no fault of his own, was unaware. When evidence is uncovered, the newly discovered evidence should be considered in light of both the evidence presented at trial and the evidence uncovered in post-trial proceedings. Here, the presented evidence is newly discovered. As discussed above, defense counsel attempted to introduce proof of Sarah Lucas's involvement in the murder through the testimony of Tammy Vance. However, Sarah Lucas lied to the jury and denied any involvement in or knowledge of Danny Harris's murder. The jury believed her. We have a footnote that says not only did Sarah Lucas recant her testimony, her confession also provides brand new information about the events of Danny Harris's death. For example, Sarah Lucas described the origin of the argument, explained how Mr. Harris was asphyxiated, and described vomiting in the bathroom, requiring the rug to be cleaned. So, critical details. 2, they're going to argue the admissibility. Newly discovered evidence must be admissible pursuant to the applicable rules of evidence and material to the issues raised in the petition. The evidence must actually be admissible at trial, not merely information that could have aided investigation. And I would say here, I don't know where the parties are located, but I mean, Stephen could lay foundation for how he had these recorded conversations, how he knew it was Sarah that he was contacting. So there's a way that even if Sarah doesn't testify to these things, they could get them in, as opposed to the Jason Autry recanting, where the state was like, "Oh, Jason Autry's too dangerous to transport, so it's not going to be admissible without him testifying to the recanting, and we can't get him here because he's too dangerous to transport," you know. So let's see. For affidavit evidence, the same evidentiary standards that apply to witness testimony also govern affidavits in Coram Nobis proceedings, requiring both relevance to the issues raised and personal knowledge by the affiant. Here, the newly discovered evidence is admissible. Stephen Harris's audio recordings of conversations between himself and Sarah Lucas are admissible because they are relevant, they were obtained legally, they can be authenticated, and they are not barred by the hearsay rules. First, the recordings are relevant and highly probative. Pursuant to Tennessee Rules of Evidence 401 and 402, evidence must be relevant in the sense that it must have any tendency to make the existence of a fact and consequence more or less probable than it would be without the evidence. Here, the evidence is relevant to the overall question of error quorum nobis tolling. Can Mr. Hayes establish his innocence? The evidence is also relevant to the overall question on the merits of the error quorum nobis statute. Would this evidence have changed the result of trial? In other words, the recordings are necessary to answer each legal question that Mr. Hayes must address in this filing, and as such, they are highly probative. Second, the recordings were obtained legally. Stephen Harris acted independently and did not act on behalf of any state agency. Stephen Harris recorded the phone calls from his home in Tennessee. Sarah Lucas lives in Oklahoma. Both Tennessee and Oklahoma are one-party consent states that allow for the release of recorded conversations as long as one of the recorded parties consents. Stephen Harris was a party to the conversations featured in the recordings, and he has given his consent for the recording to be published in this filing. So there you go. Third, the recordings can be authenticated. The recordings are a genuine and accurate representation of the conversations between Stephen Harris and Sarah Lucas. The original recordings were created by Stephen Harris. Exact copies of the original recordings are attached as exhibits to this filing. They have not been cut or altered in any way. Stephen Harris has confirmed that the exact copies of the recordings attached as exhibits to this filing are true and accurate representations of the recordings he had with Sarah Lucas in late 2025. Fourth, the recordings are not barred by hearsay rules. The recordings showcase statements made by Sarah Lucas. It is not clear yet whether Sarah Lucas would testify any differently under oath. It is possible that the rules against hearsay evidence may be implicated at a future hearing. In other words, until there is a hearing, it's impossible to know whether Sarah Lucas will adopt these statements or testify inconsistently. Regardless of whether or not the rules against hearsay are implicated, the recordings are admissible. First, rules against hearsay are born out of a concern about reliability. Here, the new evidence is recordings of Sarah Lucas's own words. The main hearsay concerns about the reliability of accurately portraying Sarah Lucas's statements are not at issue because her exact words are recorded and are not being retold by a listener. Moreover, even if the court finds that the hearsay rules are implicated, the recordings are relevant, reliable, and so critical to Mr. Hayes' claim of innocence that case law mandates their admission. And this is so important. I feel like if this is Jason Gichner writing this, he's probably soured by the response from one of the judges on the panel at the oral arguments in August of 2025 that are like, but what about the admissibility issue? And that was really the only question that the panel wanted the state to give their arguments for. And they asked a ton of questions of the petitioner. And then when it came to the state, they're like, how do you respond to their argument on hearsay and admissibility of the letters, of Heather being an unavailable witness, all of that stuff? And the panel was not having it. They're like, well, even if it wouldn't be admissible. So here they're laying it down. They're hammering this argument because they know what the appeals court, when they were asked to consider the denial of the previous Coram Nobis petition, they know what issues the appeals court harped on for that decision. So here they're like, hey, case law mandates admission. Chambers v. Mississippi, adopted by our Supreme Court in State v. Brown, mandates that to protect due process, the rule against hearsay must yield to the defendant's constitutional right to present a defense. And oh boy, aren't there a lot of cases that I feel like a judge needs to hear this. In particular, where it operates to deprive a defendant of his or her right to present relevant and reliable evidence that is critical to establish a defense. So the right to present a defense supersedes the rule against hearsay. Here, the evidence of Sarah Lucas confessing to her participation in Mr. Harris's murder, the cover-up of Mr. Harris's murder, and her confession that she knows Andrew Hayes was not involved in the murder is all critical to establish Mr. Hayes' innocence. To deny their admission is to deny Mr. Hayes due process. We're going to do the flames again. They're cooking a little bit. Cooking. And then the new evidence is credible. So, during the tolling stage, the trial court must assume arguendo the credibility of proffered evidence. But during the merits analysis, a court must determine actual credibility. And here from Garner v. State, in considering the Coram Nobis petition on its merits, the court must determine whether the evidence contained therein is admissible and credible. Courts have rejected Coram Nobis relief based on credibility concerns. And then we've got White v. State, co-defendant's self-serving affidavit properly dismissed, where she had incentive to provide favorable evidence and statements contradicted her own text messages presented at trial. And this is a great case to cite. Why? Because the contrast and the distinction between the case and what we're dealing with here points to two totally different directions. So in White v. State, co-defendant writes her own affidavit. It's like, I'm the greatest person ever. I mean, I don't know what it actually said, but she writes it on her own and it helps her. It's her own statement helping herself. It's self-serving. With Sarah and these recordings, it's not self-serving at all. Maybe in a small way, walking herself back from, I wasn't the one that was using the hammer, walking away from the most egregious murder charge, or I just helped cover down after the fact or something like that. It's still not self-serving, right? So the contrast with this case, I think, is important. And then we have Garner, which says holding newly discovered evidence not credible because the affiant was unreliable and had never testified in court. Therefore, there was no way to test his credibility. And then back to the argument here. However, if the witnesses are credible and their testimony may have resulted in a different judgment at trial, relief should be granted. Here, the newly discovered evidence is credible. The recordings showcase candid conversations between Stephen Harris and Sarah Lucas. During what she thought was a private conversation, Miss Lucas confessed to involvement in and the cover-up of a murder. The statements are so thoroughly against her own interest, not like the self-serving affidavit from the White case, and open her up to liability that it would be hard to believe she would willingly fabricate them. They were not prepared in advance of litigation, and they were intended to be private. Miss Lucas was aware of the consequences of revealing the information, evidenced by her concerns about Stephen Harris, quote, setting her up or, quote, going to the police. But she chose to share the information anyway. And gosh, if Stephen Harris is the son of Danny that worked at the sheriff's office, and if the state wanted to oppose this, again, DA Steve Mulroy says he's not going to fight this initiative. But imagine we're in a world where it's Amy Wyrick in charge and she's like, no, we never get things wrong. And Stephen Harris was the law enforcement. I can totally imagine a world where Amy Wyrick would be yelling that he's an experienced law enforcement officer. He knows how to use the Reid technique. He knows how to elicit information from a witness in a way that would sort of throw what law enforcement does every day to get actual false confessions. She would conflate it with what's happening here with these recordings with Sarah Lucas. And it would be that weird scenario where it would be a prosecutor who never wants to admit that law enforcement officers can contaminate information. So therefore a confession would be unreliable because they're feeding information about the crime scene to the person they're trying to get a confession from. Things like that. I can totally imagine someone like Amy Wyrick flipping the script, and the first time she ever wants to say we can't trust what law enforcement did would be to undermine the credibility of these recordings and say, well, Stephen Harris is experienced. He knows how to elicit and pressure and coerce information out of somebody. Anyway, that was my Amy Wyrick rant of the day. The information revealed in the recordings is further credited by other evidence in the record. Consider the evidence filed in the 2024 petition in conjunction with Sarah Lucas's new statements. There are cell phone call logs, self-tower data, and a state license that all support the fact that Sarah Lucas was with Danny and in his apartment the morning of his death. There are also numerous affidavits, letters, and recordings of Sarah Lucas's family members that support the fact that it is an open secret in the family that Sarah Lucas and Tammy Vance killed Mr. Harris and Sarah Lucas escaped consequences. Evidence from the crime scene also supports the information in the recordings. Sarah Lucas, in the recordings, described vomiting in Mr. Harris's bathroom and having to clean it up off the floor in front of the toilet. Law enforcement that processed the crime scene found a bathroom rug and a rag in the washing machine that had been washed. Law enforcement were never able to explain these elements of the crime scene, but they corroborate Sarah Lucas's confession. Finally, the recordings have legal relevance beyond this filing. They are the basis for the December 2025 indictment and arrest warrant for Sarah Lucas. In total, the new evidence is admissible, credible, was unavailable to Mr. Hayes through the exercise of reasonable diligence, and qualifies as newly discovered evidence under the Coram Nobis statute. Next, there is a reasonable probability that the newly discovered evidence may have caused a different outcome had it been presented at trial. The Coram Nobis statute requires the court to determine whether the newly discovered evidence may have made a difference at trial. Under this framework, the trial court's role is to determine whether a reasonable basis exists for concluding that had the evidence been presented at trial, the result of the proceedings might have been different. We've got a footnote here. All right, and this is about the Nunley standard, which we just read about. Courts have applied this standard to deny relief where the newly discovered evidence was unlikely to have affected the outcome at trial. And we've got, let's see, Lloyd v. State, affidavit from someone claiming involvement who denied petitioner's participation, not likely to make a difference given petitioner's unprompted admissions to the police. So you can't just write an affidavit and say, nope, that person wasn't involved, and that'll be good enough to fly. Skinner v. State, witness recantation insufficient where other witnesses and physical evidence establish petitioner's involvement. So, sure, one witness recants, but there's still enough physical evidence to say that the person they're saying now didn't do it was still there. And remember, we have no physical evidence for Andrew Hayes being at this crime scene and partaking in this crime. We've got State v. Mallard. Co-defendant's affidavit would not have changed verdict because petitioner remained criminally responsible under accomplice liability theory. And this would be like, let's say, for example, Andrew Hayes was at the property, didn't actually partake in the murder, but he was there, didn't do something to stop it. Maybe this would apply, but he wasn't there. He wasn't with the other 3 individuals. And then we've got Teague v. State. Noting impeachment evidence is only insufficient to warrant the issuance of a Coram Nobis writ when it would not have changed the result of trial. So, okay, somebody lied on the stand, but it wouldn't make a difference on a substantial fact at issue in the case for the jury to consider. Tennessee case law explicitly rejects a categorical ban on impeachment evidence in a Coram Nobis writ, explaining that to do so would be inconsistent with the discretion afforded to trial courts. And of course, the language of Tennessee Code Annotated 40-26-105 makes no distinction between impeachment evidence and all other evidence. And then deciding whether impeachment evidence is so crucial to the defendant's guilt or innocence, such that it would have changed the result at trial, necessarily involves delving into a merit analysis. So this is all, had we been able to confront Sarah Lucas with like these recordings while she testified at trial. Oh, I wasn't even there. Well, you're saying in these recordings that you were there and you saw your mom do this and you puked in the bathroom, so then we have these phone records. You want to talk about that? Like, you know, is it not true that you went and got this ID card? Is it not true that you stopped at a Burger King? So let's see. We were here. Tennessee law permits Coram Nobis relief based on impeachment evidence. So the idea that we could impeach her at trial with this new evidence should be enough. And while the new evidence certainly impeaches Sarah Lucas's credibility in her testimony, it goes beyond mere impeachment. It exonerates Andrew Hayes. Moreover, the new evidence shows that Sarah Lucas lied about her involvement in and a cover-up of a murder. It shows that she played a part in sending an innocent man to prison for a murder he had nothing to do with, and she's kept up the lie for nearly 2 decades. Had the jury heard Miss Lucas, in her own words, admit to her participation in Mr. Harris's murder and admit that Mr. Hayes was not present, this certainly would have fundamentally strengthened Mr. Hayes' defenses at trial. So, Aaron, Adventure Aaron, this is great. I think this is a great, it's just great legal writing. They're addressing every issue. To me, they're keeping in mind the issues that the Court of Appeals had with the first Era Coram Nobis petition. I think they're citing great case law, cases that are distinguished, and why that's actually helpful if you look at the opposite facts available here in this petition. And it's making me a little bit sad that the state doesn't seem to want to oppose it, because I can imagine a state prosecutor like Amy Wyrick trying to oppose this, and a court, and I'm so optimistic, even though there's a fraction of me that's just like, courts do stupid things all the time. I would love a court to say no to a state's counter argument to this, although I don't think there's really going to be a counter argument here. But I think it's great writing. I don't think we've had a single typo so far, you guys. So there's also that. But it's a great, great, great petition. I'm enjoying thoroughly reading this and learning about the different cases. We've also got, let's see, SD is asking, let's check the Fairfax County Courts. Fairfax. Let's see. So right now I'm only seeing that they're closed on Tuesday. So I'm not seeing an update that they expect to be closed tomorrow. I think they updated at noon Eastern time yesterday. So remind me before the end of the stream, we'll double check. There's been someone in the chat said that they were in Virginia and that the ice still seemed crazy. So let's check again at noon, because that's when they posted the update yesterday about being closed today. Other than that, I won't know until I see an update that something's closed. If business hours close and there isn't an announcement of closure, I would expect the au pair trial to resume tomorrow. So we'll see. Hey to Derek, good to see you. For Always Forever for Life says the facts of this case are crazy, but the fact that an innocent man is doing life is insanity. And For always, I don't know if you've gone to check out the Everything They Miss podcast, but they talk about some of the trial testimony. They have the trial attorney read some of his opening statements with, like, today, present day, reading it. And then they use voice acting to replicate certain parts of different trial testimony. Not the complete trial transcripts, because it's a 6-day trial, and it's only a 6-episode podcast. But listening to some of the things that they played, it's hard to imagine. And then it's also like the idea that juries just want to get up out of there and they'll get it wrong because they want to go home. This jury was sequestered. One had a birthday party to go to that she didn't want to miss. Like, it's just such a weird, it's a weird feeling that I can't make sense of. Like, being sequestered and wanting to go to a birthday party, would that really make you just go to guilty? When the juror says something to the effect of, well, we heard he wasn't even there, but, and then she details that she didn't want to miss this party that people were throwing for her. And she goes to lean with those that were leaning towards guilty. And then eventually they all lean towards guilty and they convict. And it's like, I've come to terms with someone taking a plea deal for a great deal like time served after they admit to shooting somebody, right? Because they want to get out of the facility. There's a lot of pressure, pretrial incarceration. It's not a joke. So I've come to terms with that type of pressure to plead to something you wouldn't want to do. But there's something in me that still doesn't want to be able to think that it's possible that somebody would convict somebody, especially for a serious charge, let alone in general, but for a serious charge where you would expect common sense. You're not supposed to consider sentencing, but in your head, you should know that, like, some aggravated murder charge, first-degree murder charge, aggravated robbery, there's certain charges where you should expect that a guilty verdict, even though you're not supposed to consider sentencing, you're looking at decades, if not life. And you would just be like, all right, but I've been doing this for 6 days and I'm over it. And I have a hard time thinking that people will crash down and play, well, whatever, it's not a big deal when someone's freedom is on the line. But I think that's the reality of it. And I still can't wrap my head around it. But I think I need to. I need to start wrapping my head around that. But I think the jury just wanted to go home there. So, Lockong Express says the DA pushing his release, that is huge. Public opinion can pressure the state. A family member of the victim has provided evidence in his innocence. I agree this is huge. I think this is, that's 2 variables that we don't usually have. I think the third variable is this doesn't seem like it was that high profile of a case. It's been very difficult to find, any information except through the Everything They Miss podcast. So shout out to Stephanie for getting all that stuff together. Really, I think a ton of work went into her podcast. So when I say it's only 6 episodes, please take that in a good light. It's a compliment on her ability to package a lot of information cohesively and in a way that makes sense, and really tells the story. But there just isn't, this is not like the Holly Bobo case where I was able to go back and find 200 videos on YouTube of prior media coverage, right? And maybe for better or for worse. Because in a way with the Holly Bobo case, I think some of that media coverage where you have the B-roll running constantly of Zach Adams' backyard being excavated, probably instilling the idea in the community's minds that they found physical evidence of Holly Bobo at Zach Adams' property, which is not true. It never happened, but those images ran over and over. So maybe it's like blessing and curse that this wasn't a high-profile case to start with. But at the same time, if the loss of Danny Harris had been publicized the same way as Holly Bobo, I think there would be the pressure to get the right person. And without the DA taking the initiative on his own, I think this would be a big issue. I think, what does it matter if someone's sitting there? So, Angela says, schools are closed until Thursday and that the ice is terrible by you. Oh, that sucks. Was it last year? I'm losing track of time. I think it was last year. It was last January. So, I was working, I took like contract work with, my brother used to work for High Res Studios. So if you guys know the game like Smite or Smite 2 or Paladins, for that. And they did their annual esports competition, their Smite Championships. It was the 10th year of Smite Championships. And it was in Dallas at the esports convention center in Dallas. And that's when the ice storm hit in Texas last year. So we do the tournament when we're leaving. It's like, it's so cold outside. And all these gamers, they're just wearing t-shirts. And we're loading up the computers in the car. Everyone's freezing. The next morning when we try to drive home, it was like a 14-hour drive to get from Atlanta to Dallas. I think it was 14, 17. I forget, but we stopped a few times. It took us like 17 hours just to get to Shreveport, leaving from Dallas because of the ice. And there were trucks off the road. There were so many cars off the road. We stopped in Shreveport for the night because it took us as long as it took us to get from Georgia to Texas, just to get from Dallas to Shreveport. So we stopped, and I remember getting out of the car at the hotel, and I was like crawling to the hotel door. Like, ice is crazy. It is not a joke to try to walk around on that. So yeah, my mantra is, if it's icy outside, just don't even go outside. Yeah, Tina says here, I would hope that the newly found evidence would lead to no trial at all for Hayes. I hope so, and I think, again, tying back in with what Law Kong Express said, I think it's critical that the DA is essentially like cooperating with the defense initiatives here. Because there are prosecutors out there. I'm sure you guys can come up with your own examples. Maybe Morrissey's one, maybe Wyrick's one. That would just, nope, we're going to continue fighting to keep someone imprisoned. We don't care if you have new evidence. We were right. So, yeah, Gwennon says juries so often get it wrong. Too many people still think that if someone is arrested, they must have done it. Hey, Demal, good morning. We've got For Always, Forever, for Life member for 18 months. Thank you. Says the fact that a man is doing time for this is sick. And to hear, like I get it. If you can get away with something and not tell on yourself, okay, sure. That I could see why somebody would try to like go be a fugitive, never get caught, protect themselves from legal consequences. But there's also a layer here where law enforcement was on alert. And even with these petitions throughout the years for relief, for post-conviction relief for Andrew Hayes, why is it a relative of the victim that has to go and get these answers? Because all that means to me is that the Memphis Police Department was fine closing the case. Not solving the case, not getting justice, not getting it right, but closing the filing, closing the case, marking it as a checkbox. So MPD couldn't do what Stephen Harris is able to do in, like, what was that, like a 2-3 month time frame after last year's oral arguments. So it is sick. And, you know, who's to say that the same process, like this 27-hour interrogation, who's to say that there isn't a similar case where somebody's behind bars for the same shoddy work? We just get to close the case and we're fine with that. Just crazy. And I really think that it's critical that Steve Mulroy is involved here. And that Jason Gichner got involved. That Stephanie got involved. Because something, and it was Jason that made the oral arguments, something must have just been marinating for Stephen Harris to sit there and say, you know what? I'm going to take this into my own hands. I'm going to get the answers and I'm going to record it. And then, what do you know? It panned out. Which I still can't believe she, like, quickly was telling on herself over the calls, but I'm glad she did. Ejetta says, Happy New Year, and I miss each of you. Right back at you. Hope your January is going well. Thank you for being a member for 17 months. And we've also got the Kathy in the bushes emoji. Love to see it. Hey to Kels, hey to Dustin, hey to Grandma Ninja. Yeah, Kristen says this is wild, such a different story than what we heard yesterday. And again, I do think a part of that is, yes, Sarah is admitting something to the victim's son, but she's admitting things in a way that make her seem like the situation fell upon my lap. I didn't initiate the incident. I helped my mom maybe because that was my mom, but I didn't hit Danny. I think the difference is Sarah's still not telling the full truth. That's where I weigh on it. But either way, as this motion is doing a great job pointing out, either way, Hayes is innocent. Hayes was not there. Hayes wasn't part of this. So Derek says these days you can't trust a jury as they don't care if it gets them home to get on with their lives, not give into the consideration to the person who's going to jail, so they just don't miss their party. Yeah, and I think it's scary. And again, it goes back to the everlasting dynamic between the decision to take a plea deal and the decision to take it to trial. There's absolutely a reason why an innocent person would take a plea deal, because the behavior of investigators could help put together some scary, compelling evidence against you, even if you didn't do it. The jury could look at that evidence and go, well, we're going to believe it on its face. Obviously, they thought they found the right answer here. This has to be what it is. The alternatives seem a little crazy. Yeah, we're just going to convict. So, so we've got here the next argument is Mr. Hayes exercised reasonable diligence. So again, this has to be no fault of the petitioner that this evidence wasn't available to present at the time of trial. So a petition for writ of Coram Nobis must show why the newly discovered evidence could not have been discovered in a more timely manner with the exercise of reasonable diligence. The question of diligence in bringing new evidence was highlighted in Harris, where the Tennessee Supreme Court held that, in order to gain relief, the petitioner must demonstrate that this evidence could not have been discovered in a more timely manner with the exercise of reasonable diligence. In Harris, the court found the petitioner was not reasonably diligent in bringing alibi evidence because the petitioner failed to mention his alibi evidence to law enforcement, to prosecutors, or his own attorney, failed to attempt to locate his alibi witness prior to conviction, and had previously testified in a manner that was irreconcilably inconsistent with the new alibi evidence. Here, Mr. Hayes has exercised reasonable diligence in bringing evidence of his innocence to the court's attention since the time of his conviction, demonstrated by efforts of his original defense team and numerous filings throughout the years. Sarah Lucas lied at the 2010 trial, and Mr. Hayes had no means of extracting the truth from her. The law requires reasonable diligence, not extraordinary diligence. We got another one going here. It's a nice little line. Stephen Harris's actions were extraordinary. Andrew Hayes, so this is the guy that goes and gets these recordings. His actions are extraordinary. Andrew Hayes, through all of his efforts over the years, he's also been incarcerated this whole time, was unable to achieve the results that Stephen Harris, motivated by the desire to solve the crime against his father, was able to achieve. In conclusion, if new evidence considered in the context of the entire record creates a reasonable probability that there may have been a different result at trial, then the petition for writ of Coram Nobis must be granted and the petitioner afforded a new trial. In this case, newly discovered admissible facts demonstrate a reasonable probability that a jury would have acquitted Mr. Hayes because of highly probative evidence linking Sarah Lucas to the crime, especially after considering the absence of any reliable evidence linking Hayes to the crime. Because all they had was he might have been helping them move a TV. And then Tammy's word some of the time. Because Mr. Hayes is without fault in failing to raise this evidence earlier, and it would have influenced the jury's decision to convict, Mr. Hayes respectfully requests that this court grant his petition for writ of Coram Nobis and afford him a new trial. So in conclusion, Andrew Hayes has spent the last 18 years incarcerated for a crime that he did not commit. He moves this honorable court to grant an evidentiary hearing and an order granting the writ of Coram Nobis petition, vacating the conviction, and granting a new trial. So you've got Jason Gichner, Jessica Van Dyke, Madison Lowry from the Tennessee Innocence Project, signing off as attorneys for Andrew Hayes. We have an exhibit list here, but I didn't see the actual exhibits here, so I don't have them, unfortunately. But we got to read, I think, important parts of those call recording transcripts. So there we go. And again, Steve Mulroy said we're not going to fight this. But I feel like this was so well written that I think even if the state wanted to fight against this, I still think, and I would hope, that it would be successful and that they'd at least have a hearing. You know what I mean? So, and then ultimately with the end goal of vacating the conviction. So, with that being said, that catches us up to present day. I haven't seen an update on, any news stories like Sarah's officially over in Tennessee, but I'll keep my eye on that. We did have, if we wanted to work backwards, because I only saw this yesterday, this was oral arguments from April, was it 14th? April 14th, 2017. So these were oral arguments on the appeal of the denial of the 2013 petition for post-conviction relief. So we can listen to this just to hear, I think this was Attorney Jones, and just to see what was argued. Let me put up a banner so people know that this is from, let's see, April 14, 2017. And I can't spell today. Okay. So we've got a banner there, so people will know that we are back in 2017. And for Always Forever Life says, next the lawsuit for wrongful conviction. So there's a story, I'll probably just do one video on it, I'm not that invested, but I did see a story, it was the Rensselaer, like it was a DUI case, someone was convicted, they were like driving, and it was them and a friend in a car, the car flips, and they end up convicting the survivor, and of course the theory was that he was driving, but I guess there was a dispute over the driving, the rates of speed, and now that conviction was overturned a few years ago for for issues I think you guys are going to laugh at. Let me give you a preview. Let me read a quick preview out loud, because this is the exact thing I read, and I was like, oh gosh, we might have to talk about this. All right, let's see. Hopefully no pop-ups. All right, no paywall. Let me find where it mentioned. All right, so this is the part. I'm searching for the word shadow. So they are now suing a civil suit, for this wrongful conviction. They want, you brought this wrongful conviction forward. You were stupid. And there's a civil suit now. They're suing the prosecution. And that's why I'm interested in it. But I saw this detail where I was like, oh my God, are we for real? So a key argument from Rubin: faulty information influenced Hoffman's original conviction. Investigators measured shadows from utility wires as tire marks, creating faulty readings about the speed of the car. Despite knowing about problems with the findings, prosecutors didn't disclose that evidence to the defense, according to the lawsuit. They measured shadows from utility wires as tire marks. Like, chat. Like, what are we doing? What are we doing? So I was going to do something, I don't know, one of these days, just going through this, because again, now it's a civil suit. Quick summary. Let's see. Formerly incarcerated Steventown man, once convicted of manslaughter among other charges, is ready for another day in court nearly 3 years after his conviction was overturned. Brendan Hoffman, 34, is suing authorities and prosecutors involved in a 2012 single-vehicle crash probe, findings of which led him to serving more than 8 years in prison for the unintentional death of his friend, Christopher Baker, while intoxicated behind the wheel. Those allegations a newly filed 51-page complaint filed in the U.S. District Court of Northern New York were unjustly delivered and bogus. So they're saying that it arose and it's supposed to be a unanimous condemnation of prosecutorial and law enforcement misconduct. Officials with the Rensselaer County Sheriff's Office, State Police, and North Greenbush Police Department alleged that Hoffman and Baker had been drinking alcohol and smoking cannabis before driving on Cranston Hill Road in Stephentown. Their car swerved over a double yellow line, hit culvert piping, and flipped over repeatedly. Baker died, and Hoffman left the scene. Hoffman served 8 years before he was put on parole. In 2023, he had his conviction reversed in a unanimous ruling from the Appellate Division of the State Supreme Court's Third Department, which found that there was no direct evidence showing who drove the 2000 Dodge Neon that night based on investigation findings. This came after Judge Deborah Young tossed out a motion to vacate the conviction 3 years earlier. Manhattan-based attorney Aaron Rubin represented Hoffman in his conviction reversal. He's also representing him in the new civil case, echoing arguments he's made in the past. A key argument, and this is where it's kind of like, all right, this is like wishy-washy or whatever, like, maybe he still was the guy. Who knows? Jury decided. But how did the jury get there? So faulty information influenced Hoffman's original conviction. And this is the shadow part. They measured shadows from utility wires as tire marks, which could give them the improper impression of where the car went off the road, that the car was swerving at all. Like, there's a lot of reasons that alone could be an issue. But they also used it to make readings about the speed the car was going. Even though they knew that there were issues with this finding, they didn't disclose that evidence to the defense, according to the lawsuit. In 2019, accident reconstruction expert and retired North Greenbush Police Sergeant Douglas Pinzer submitted a sworn affidavit saying that he was never at the scene due to overtime issues and that investigators butchered evidence. According to him, he was blamed for the false calculations. The prosecution weaponized this unchecked misconduct, obtaining a second indictment on false premises, orchestrating witness exclusion, exploiting the defense's experts' knowing reliance on fabricated measurements at trial, and securing a conviction on evidence they deliberately refused to verify. And there we go. He wants punitive damages against the individual defendants in an amount that will deter future violations. They want a jury trial. So they've got, let's see, the defendants will be Rensselaer County as a municipality, the town of North Greenbush as a municipality, as well as assistant prosecutors, officers, and law enforcement agency leaders in power at the time, such as then District Attorney Richard McNally. Rensselaer County Sheriff Kyle Burgalt, who was involved in the case at the time, North Greenbush Police Chief David Kevern, they declined to comment, and the District Attorney's Office and the attorney representing the plaintiff here didn't respond to a request. So I thought this was a good time. So the guy the reconstructionist doesn't go to the scene. He's working off a photograph, but the photograph has shadows of power lines and isn't actually tire marks. So I think that's interesting. And then again, we're suing the prosecutors, suing the investigators. So I think if you guys want, we could pull that filing. We can read through, at least the statement of facts in the lawsuit. So what the plaintiff is saying happened and why it's a problem. I couldn't believe that though. Pictures of shadows of power lines. But it was being used to reconstruct the accident as if it was tire skid marks. Yeah. Sheriff Chuck says, shadows from overhead utility lines could mean they skidded for thousands of yards going 300 miles per hour. Just crazy. Yeah, Les says, I feel like it needs to be a new system in place that needs no jury. Jurors really don't care. This clearly shows that they don't look at evidence. You look guilty, then you're guilty. They don't look at evidence. And it sucks because I think there is a beauty when the jury system gets it right. I mean, look at the pandemonium that ensued after Karen Reid at trial 2 was acquitted. And again, they convicted her of the charge relating to operating under the influence. It's not like they just said, straight acquittal down the board. To me, that's indicative that they looked through the case. But they went through the evidence, and I think a lot of people were pissed off about that. But you have a team of attorneys that, and they had a juror from the first trial as part of their jury consultant team, right? So during the voir dire process, they had a juror from trial one help as a consultant to pick a good jury for trial 2. And I really think if you don't get that jury selection process right, it's over. It's over before the opening statements even start. So I'm just seeing this. This is hilarious. Learned Hand Knit says Banfield weather update. Fairfax County side streets are still ice cubes. Virginia Department of Transportation probably decided it's a lost cause. I read this and thought you meant the trial itself. And I'm like, well, yeah, kind of. But yeah, I think jury selection alone can make or break the case. And this jury here, we heard issues we read about yesterday that someone that worked with the son of the decedent at the sheriff's office was on the jury pool. They weren't struck. So, it's like when it works, it works. But when it doesn't work, it's like impossible to correct because you'll have prosecutors like Amy Wyrick going, 12 jurors looked at the facts in this case and they convicted the defendant. So, yeah, maybe a rebalance to take away some of the state's advantages. I love hearing when in the Uvalde interviews. So Ian Runkle did one and Justice Serve TV had Nico on yesterday. I think Jason and Nico were on with Runkle, and then Nico joined with Justice Serve TV. Both great interviews. But they talked a bit about during, and they're in Texas, so they say voir dire. They, you can't talk about facts of the case during voir dire, but during your questions, you can ask sort of things like, if you were to hear this type of argument be made at trial, would you take that as us blaming the victim blaming? Would you be able to understand that, for us to present our case for Adrian Gonzalez, we're going to have to talk about some hard things. And that's not us taking in any way trying to shame the victims. And when attorneys are very aware of the way that they can use the voir dire process, I think it sets the tone. I think asking those questions is not only helping you select or deselect the wrong people from the veneer pool, but it's also creating a framework. Already in that process, you can be anchoring the jurors to be considering certain things when you start to deliver your opening statements, when the state starts to put on their evidence, and if you put on a case in chief as the defense, when you put on your own arguments. So I think voir dire isn't just about selection or deselection of the jurors that are going to sit to consider the facts of the case. It's also the initial anchoring. So I like when attorneys talk about that strategy, and Jason and Nico discussed that a little bit with Ian and with Justice Serve TV. Really, really interesting and enlightening interviews. So make sure you guys check those out if you are interested in that stuff, even if you weren't interested in the case itself. Yeah, Dustin says, I'm just getting back, but who measures a dang shadow? Shadows move based on the light. Listen, I don't know. So I thought it was exciting to see someone suing a prosecution team for a wrongful conviction. I did not expect some dumb detail like that when I opened the article and got a quick sample. But yeah. We've got, let's see, it is noon, so let's do a weather check over at Fairfax, and then we'll play these oral arguments that I've had sitting on the screen while I rant and bant. Alright, so right now it's past noon, but I still don't see anything other than that they're closed Tuesday, which is today. So if there's court tomorrow, I'll be live doing the next day of the Banfield trial. If there's no court, you won't see me live doing that trial, but maybe we'll do something else. So let's listen to again. We are going to be back in April 14th of 2017. The quality isn't great and there's no captions, but give an hour, and some of this is lower, it's harder to hear, but closed captions should populate from YouTube about an hour after the stream is done. So if you want to get out of here and come back and watch this, that's fine by me. But let's get into it. This is going to be Attorney Jones, and Zettner for the state. So again, this was the brief that Amy Wyrick was part of the briefing, but unfortunately, and it's why I looked, she wasn't the one that did oral arguments.
Yes, sir. Call next case, please. Yes, sir.
Good morning, Your Honors. James Jones here on behalf of Andrew Hayes. Your Honor, if I could request 5 minutes for rebuttal.
All right, sir.
May it please the Court. Your Honor, before you today, there's one main issue that we would like to elaborate on, and that's whether the trial counsel was ineffective for his failure to call a material witness. The reason why this case is, or this particular issue is so important is just mainly because of the type of case that this is. This is Mr. Hayes was charged and ultimately convicted of felony murder and perpetration of aggravated robbery. This robbery or this attack on the victim took place approximately August of 2007. They're not quite sure of the exact date because he was found or discovered sometime later, and so based on the decay, and they believe it was sometime in August. What is critical in this particular case is that Mr. Hayes wasn't developed necessarily as a suspect, but was more along the lines stumbled upon. Mr. Hayes went to the police station, or Tammy Vance, who was developed as a suspect, was being questioned along with her daughter, Sarah Lucas. Mr. Hayes went to the police station to pick them up, and when police asked who he was, he gave his name, and that ultimately sparked the police to begin asking him questions. And several hours later, and several inconsistent statements later, a statement was given that he participated in this activity or in this crime. Now, that was the only thing that linked Mr. Hayes to this offense. Tammy Vance, who was the prime suspect in this, stated that there was a person that assisted her, and she gave a name of a Wayne Bobo, originally a false name. Andrew Hayes, his middle name is Dwayne, and he sometimes goes by the nickname Wayne. And so that is how he was brought into this. But there was never any items or any artifacts that were discovered that Mr. Hayes had, or he was in possession of any of the articles of this crime. And so that is why this particular witness is so important. The state's theory in this particular case is that this robbery took place. Tammy Vance was the victim's girlfriend. That this robbery took place, and in particular, a very large big screen TV was taken from the victim's home. The state made this a very key part of their theory of the case. In fact, to the point where the prosecutors brought this TV out during the trial, the case in chief brought it out during the closing arguments and demonstrated the prosecutor's inability of moving this TV by herself, and that a strong person would need to be there to help take this piece of property. The problem that we have in this particular case is that there was a witness that was discovered prior to trial by the defense counsel's investigator that stated that Miss Vance and her daughter, Sarah Lucas, brought the TV to the house where Mr. Hayes had been sleeping. He woke up and was assisting unloading it. He didn't have, or according to the witness, it wasn't out there with them, didn't come with them or anything of the sort. The reason why this is so important is because Sarah Lucas was part of the defense theory's case in chief, as far as Sarah Lucas was the person that assisted her mother in committing this crime. This was also corroborated by Tammy Vance, who began testifying and stating it wasn't Andrew Hayes that committed this crime with me, it was my daughter, Sarah Lucas. This information, as testified in the post-conviction hearing, was brought to Mr. Garrett's attention prior to trial. Mr. Garrett
Hey,
did
Tay
not
Biz.
choose to not call this witness. He didn't even talk to her.
And what's the witness's name?
Her name was Mary
Wheeler?
Wheeler, excuse me, yes, Your Honor. Mary Wheeler. That witness, even though this came about 6 years after the offense, came to court in the post-conviction trial and stated and testified, I remember Andrew Hayes was in the house on this particular day because we were doing work on our roof. Andrew Hayes was going to help me with the roof, and help me with that. At that time, Tammy Vance and her daughter, Sarah Lucas, came up. They had the big screen TV in the back of their truck, and they called and asked Andrew Hayes to come out with them unloading it and ultimately put it in the house. At that time, according to Ms. Wheeler and Andrew Hayes, they had no idea that this was a stolen item or anything of the sort.
I take it Ms. Wheeler testified at the post-conviction hearing?
Yes, Your Honor. And that is, this witness had always been cooperative. This witness was always available. Mr. Garrett, it can't be said that it was strategic in not calling her because he never even talked to her. Mr. Chapman, Clark.
Remember that this is still ineffective assistance of counsel was the argument at the center of this petition for post-conviction relief filed initially in like 2013.
Chapman, who was the investigator on this case, talked to Ms. Wheeler, got a recorded statement, and brought it to Mr. Garrett and said, hey, we have a witness, and Mr. Garrett completely disregarded it, never followed up, never looked at it, never went any more into looking into who that witness was. Now, the state's response to this argument is, well, the jury didn't believe the mother testifying that the daughter was involved, so how would or why would they believe this person? Well, for the very reason that this person doesn't have a dog in the fight. This person, the state's theory, the complete theory, one of their main points was that with this particular evidence, it was not possible for Tammy Vance to do this alone. She needed someone strong, and that's how they put him into this, to corroborate all of the inconsistencies in his statement. There were other issues with regard to his statement.
And hold on, this is crazy listening now. Like, so today we got to read through transcripts of the recorded calls with Sarah Lucas Reidel, where she's describing that at the very least she may have helped her mom, Tammy Vance, hold down Danny Harris while he was being killed. But now it's like the two of them can't move a TV on their own, even though they're pulling up with the TV in the back of the trunk.
One being his mental capacity. Mr. Hayes had a just very slightly above mental retardation IQ that was brought out in trial. That was one of the other issues that we presented in the brief, and I understand that there's issues as far as Black v. State and not presenting another mental evaluation. But Mr. Garrett, in that particular instance, also failed to call a witness to corroborate the school records in which he had his evaluation done. And because he had waited so long, the only thing that he was able to do was call the school, and he was luckily able to bring someone from the school that could read the records, but that person did not have any contact with Andrew Hayes in the 5 years since.
Back to Ms. Wheeler.
Yes.
So, but all she really could testify to was that moment in time.
Yes.
She has no idea what the petitioner was doing 2 hours before that, the day before, whatever. So she doesn't know whether for all she knows, he helped with the theft, helped load it in the truck, and then he came home and went to bed, and then they came by the house later. I mean, all she has is that little window. It doesn't acquit him, so to speak, of the offense. It's just that little window of time, correct?
That would be one way of looking at it, yes, Your Honor. The fact that This was one early morning, and so there is the possibility that he could have went and loaded the truck and that he came back to the house and subsequently they came later on with it. But with all of the focus between Tammy Vance saying that it was her daughter, there wasn't anything that the defense really had to support that claim. They didn't have anything other than Tammy Vance saying it's my daughter. And although that is a very real indictment that a mother would somehow accuse her daughter of committing such an offense, they didn't have anything material to support that theory of defense, except that they had Miss Wheeler, who said that the victim's TV was brought to the house by Tammy Vance and Sarah Lucas. This would have corroborated the other things because there was a lot of inconsistencies in Miss Lucas's statements as well, which if there was a piece of, now we have a piece of evidence that was taken from the crime scene that can directly be linked to Sarah Lucas, that could have shifted everything because there was so much murkiness in the water, I guess you could say. The only thing that they had was Tammy Vance saying that Mr. Hayes was not involved, it was my daughter who did this, and then some inconsistent statements that Mr. Hayes had participated in. There wasn't anything really supporting the defense's theory that Mr. Hayes wasn't involved in this except this witness. That's why this witness was so important. This witness was available before trial, she was available during the trial. 6 years later, she was still available and still remembered very clearly what was going on that day. As far as what could have happened, I mean, we were going into the speculation of, whether the jury would have thought or what they could have looked at. But as far as what Black requires, and this is one of the situations where the state so often and with post-conviction gets to stand on the position of, well, the defense wasn't able to produce a witness to support their theory. And that is where post-convictions get shot down over and over again. Well, we finally have a witness that came forward that is a material witness to this case. So for the state to come and say now, well, okay, they did that part, but that witness really isn't important. Well, it's having their cake and eat it too. And so we would suggest not trying to speculate as to what the jury necessarily would have done or what analysis they may have come to. We have a material witness that the defense had. We have her testimony of what she would have testified to, that Mr. Hayes was home at this time when contraband, or rather evidence of the victims was brought by Sarah Lucas and Tammy Vance to the home, which, yes, it could be believed that someone else loaded the truck, but we have also the same belief and the same reasonable belief to think that Sarah Lucas was somehow involved, which supports the defense's theory. But none of that was ever presented to the jury because the defense counsel didn't even entertain this witness. Now, if we look through the testimony of even Mr. Coleman Garrett during the post.
Well, I mean, I do hear the words, but I would describe it as very low energy word salad. So, unlike Jennifer Thompson's high energy word salad.
Conviction hearing. And during some of the actions, a lot of this was over eagerness. It seemed so clear, and Mr. Garrett even said, it seemed so clear that this case was an open and shut that he believes that may have been reasons why he didn't do certain things. Well, that is not a sound strategy. We don't have the comfort or the ability to say, well, our case is so strong, I'm just going to disregard witnesses. In this particular case, a man is serving a life sentence because he was not given a fair trial. And at the end of the day, that's what this is all about, is someone being able to get a fair trial. And at this point and at this stage, the hurdles are so high in order for someone to receive any form of relief, especially when you're dealing with testimony. This particular witness is critical to the case. That in and of itself would strongly support the defense theory that Sarah Lucas was now involved, because now contraband. Again, there was never any pieces of evidence found with Mr. Hayes. The only piece of evidence that was ever recovered was brought to the home by Sarah Lucas and Tammy Vance. And that testimony was never brought to the face of the jury. And for that reason, we would ask your honors, and with regard to the other points, we would submit those on the brief. But for that purpose, we'd ask your honors to overrule the post-convictions court and allow Mr. Hayes to have a fair trial, unless there's.
All right, so you can see just by the wavelength thing that SoundCloud puts here, we're going to have a step up in the energy when the state responds. Like, look at the difference this whole time versus this block here.
If there's any other questions, I will sit down.
6 minutes, please.
Thank you, Your Honor.
Yes. Sir, Jenna.
Good morning, Your Honors. May it please the Court, Jeff Zentner on behalf of the state of Tennessee. This entire theory that the defense propounds with regard to Ms. Wheeler and Judge Dyer has identified the problem with it, that it is premised on one giant assumption, that the fact that Mr. Hayes was at home at the time that Ms. Vance and Ms. Lucas drove over with the television means that he could not possibly have helped load the television into the truck at some earlier time. That is the assumption, but not only is there no proof that that assumption is correct, that the defense could have put before the jury, there is in fact proof from the defendant's own mouth that it is not correct. So if we look back at the trial record, which I've set forth in my brief, I'm going to read just a snippet of it. This is Lieutenant Ragland testifying about what the defendant said. He said that he and Miguel loaded the television into the victim's truck and that Ms. Vance also removed a VCR and a DVD player that was built together and DVD movies. He said that they left the victim's apartment and traveled back to the DePass Street residence to pick up Ms. Lucas so that Ms. Lucas could pawn the items. The defendant told Lieutenant Ragland that he did not tell anyone about seeing the corpse in the apartment because he was afraid that he would be charged with the victim's murder because he had helped move the television. So what we've got here is that the defense is essentially saying that this great assumption should have been placed before the jury when in fact the defendant's own words contradict this assumption. There's just no proof whatsoever that Ms. Wheeler could offer that Mr. Hayes was not there at some earlier time to help load the television into the truck and for Ms. Lucas and Ms. Vance to then bring it over at a later time when Mr. Hayes was at home. There's no proof of that at all that Ms. Wheeler can offer. So Ms. Wheeler's proof would have been of the most marginal importance at best. And it comes in the, and you have to look at the universe of proof in this case. There was good proof on both sides. On the state side, yes, the state did not have physical proof linking the defendant to the scene, which was in fact the cornerstone of the defense's theory at trial. What the prosecution had was the defendant's confession, and that's always powerful proof in front of a jury. On the other side, the defense had excellent proof in the form of Ms. Vance testifying against her own daughter, that her own daughter committed this murder. And in fact, there was physical proof that corroborated Ms. Vance's testimony regarding her daughter's involvement. She said that her daughter struck the victim, I think, 7 or 8 times with a hammer. Well, there was testimony regarding the blood splatters, that it looked like there were blood spatters that indicated between 6 and 8 strikes. The autopsy indicated blunt force trauma. So the defense was working with excellent evidence, and there's just no reasonable probability of a different outcome if this proof, which was premised on a giant assumption that was contradicted by the defendant's own confession, if this proof had been admitted, it would not have made any difference. There's no reasonable probability of it having made a difference. With regard to the other arguments the petitioner puts forth, We will rest on the arguments of our brief unless the court has any questions. And if there are any questions generally about this case, we'll be happy to try to answer those. Otherwise, we would respectfully ask this court to affirm the post-conviction court. Thank you.
Anything else, or is that?
Yes, Your Honor.
Sure.
Your Honor, may it please the court, the state speaks of there not being any proof to support this assumption, and that's exactly the point that we're bringing up, is that this particular witness, Ms. Wheeler, testified that she was there, Andrew Hayes was there, and that this piece of evidence was brought to the house. The victim's evidence was brought to the house by Ms. Lucas and by Tammy Vance. Ms. Vance gives a very detailed, and the state is right as far as that particular evidence. Ms. Vance gives a very detailed account of what took place that night with her daughter and with the victim. Now, the state wants to refer to Mr. Hayes' confession. However, this confession isn't just a one-statement confession. The confession was given, or statement, a different form of the statement was given 3 different times over more than a 12-hour period. During this time, Mr. Hayes gave a statement. That statement was told by the police told Mr. Hayes that statement wasn't correct, wanted him to give another statement. He gave another statement. He was told that statement was incorrect. He was so hysterical that they said that they had to take a break from it, and that he ultimately came back with another statement that still was not as detailed or correct according to the evidence as Tammy Vance's statement. So to rely heavily on this particular statement of what was being said or was supposed to have been done by Andrew Hayes, a man who has, I believe, somewhere in the range of a 65 to 70 IQ, over the course of this interrogation, I believe would be faulty. We have a witness. The witness that, as we stated before, is generally so elusive to be able to procure for a post-conviction, who stated that evidence from the victim was in the possession of Sarah Lucas and Tammy Vance. There was never an opportunity or ever anything presented by the state to contradict or state that was loaded by Andrew Hayes previously or anything of the sort. And if there was presented in the state, by the state through his confession, there was a duty by Mr. Garrett to present this witness to say, hey, hold on, Mr. Hayes was over here. So, and not just in order to support their particular theory, he would also be able to and should have presented this witness to negate the theory of the state that Mr. Hayes was the one that was involved in this. For those reasons, again, Your Honor, we would ask that Your Honor realize the weight of Mary Wheeler, realize in this particular case, how significant when there wasn't anything to link Mr. Hayes to this offense other than his statement over this course of period of time, and the fact that the defense counsel had an opportunity, not a strategical decision, not no other reason, but completely left out a witness, did not even talk or interview this witness, and allowed his client to go forward with a theory that was unsupported. And for that reason, Your Honor, we'd ask Your Honors to overrule the lower courts and allow Mr. Hayes to have a trial. Thank you, Your Honor.
So there we go. Oh, and this is just some random case playing next. But yeah, so that was pretty low energy, if you guys remember from yesterday, or just figured it out by the fact that we have to have a new petition filed in 2026. That was denied. That was denied. Those oral arguments did not convince the Court of Appeals to reconsider the lower court's decision denying the 2013 petition for post-conviction relief. So I think that catches us up with everything as far as what's available through the docket on the Andrew Hayes case. again, of course, I'll be looking for any updates and maybe responses. Like maybe the state will file something that's like, bro, we're not fighting you, signed us from the state. like maybe they'll file something. I don't really know how that works, if they file something procedurally or if they just don't file a response and then they just wait for the judge to weigh on the petition without their response in opposition. But I'll keep looking. And then I don't see a weather update for Fairfax County. So again, we've been watching the Brendan Banfield trial. If that's on tomorrow, we'll be live covering that. If that's not happening tomorrow, if they're closed, I think we'll talk about this case that I see Andrew Fleischman giving an update for. It's he won a case. He helped a client sue a lawyer for double billing. That lawyer tried to file an anti-SLAPP to get it shut down, and the court was like, this isn't protected free speech. You shouldn't be double billing your client. And now he posted an update saying, hey, we were initially suing because the criminal defense lawyer, who was also the elected misdemeanor prosecutor, double billed his client for an unnecessary security deed to get a bond. Now it seems that the prosecutor owned the bonding company too. So, good bedfellows going on here. So maybe tomorrow, if there's no Banfield court, or maybe during the lunch if there is Banfield court, we'll see what's going on over in Georgia, because there's always something going on over in Georgia. So looking forward to that. I did share the link to that article in the chat. So thanks for watching this live if you tuned in to hear the story of Andrew Hayes. I think it's important to talk about. If you have not yet already checked out the Everything They Missed podcast, and I really want to see the numbers go up, because this is, when we read dockets, it can piss us off, but there's just another layer about what, same thing with Trial and Error podcasts. They were able to speak to John Walker. They were able to go to Zach Adams' house. They were able to speak with Jennifer Thompson and Zach Adams' grandfather. And I saw how you guys all were able to react when we got to see Cindy Adams on screen after the closing arguments for the Coram Nobis proceedings. But these views are really low. And the story, the information that Stephanie puts together is incredible information. So if you have not already checked it out, or if you haven't told your friends about it, anyone that you know that might be interested in true crime or wrongful conviction stories, or they just want to see what's going on in Tennessee, I think it's got all of that there. So let's keep talking about this podcast, because that's the reason I saw the article that let me know about this case, because the article mentioned this podcast. And I don't think DA Steve Mulroy would have made his announcement on the innocence if the Tennessee Innocence Project, Stephanie Tinsley, and now we know Stephen Harris entered the ring by trying to go talk to Sarah himself. I don't think we'd be here without any of those steps, right? Like the butterfly effect. You remove one effort. Without Stephanie, we wouldn't be here. Without Jason, we wouldn't be here. And without Stephen, I don't think we'd have the confident declaration from the district attorney. So I think it's really important not just to hear the story and really understand everything they missed and why they missed it, why they were so happy to just close the case going after Andrew Hayes, a black man with a learning disability, who they were somehow able to get details magically from after a 27-hour interrogation. I think it's just an incredible story to tell, to pay attention to. And here we did the docket dive, but it's not the same as hearing some of the voices, hearing the trial transcripts, and the people aspect is presented through this podcast. So please make sure you check that out. Yes, also, Dana was on with Miss Good Janet Demeanor yesterday. That was a great interview. And they're hinting at, possible new information coming forward. So, and I think Katie has also teased at, a new episode, a new interview soon. I don't think that's the same thing that Dana was talking about yesterday, though. So I believe there's more to come. And I still have not taken the time to listen to the full Dylan Adams interview, but I'd mentioned it yesterday. If you guys have already listened to it, let me know. Let me pull up Trial and Error. Trial and Error. But they've now got, see, it's like 4 hours, so way longer than the clips that we saw either through the podcast or through the proceedings. So make sure you're checking this out. And I know it looks like I played it, but I don't know. I was looking for something and I jumped to this part of the video. I have not listened to it yet. So I've got to do that. But remember, just because these proceedings are done does not mean that Katie stopped, that Dana stopped. Dana has also mentioned several times now to be on the lookout for some differences with, you know, everyone's like, well, what about Dylan? What does this mean for Dylan? And Dana has said that, hey, there's going to be some motion. There's going to be some action on Dylan Adams' behalf soon. And because it's a different person and he's dealing with an Alford plea and it'd be a different pathway, there might be different arguments made. There might be different points of error discussed that, you know, we didn't really get to see with the motions for Zach Adams. So again, that's another way we could hear some things for the first time, or at least argued for the first time in like a filing. So gotta stay tuned, gotta keep the pressure on. And did I drop everything they missed? Okay, so everything they missed is also linked in the description. But for the off chance that anybody here has not already checked out Trial and Error podcast and the work that they've done for the Zachary Adams wrongful conviction, there is their channel. I mean, the deep dives with both are just, it's an incredible depth, an incredible behind the scenes look at just like what can go wrong. And in these instances, unfortunately, for Zach Adams and the others that were accused alongside him, and for Andrew Hayes over in his case, the real results of the impact, somebody losing their freedom, life sentences, the person who actually did it, still out and about free, maintaining their freedom because we don't get it right. Like, these creators are showing, and really they're doing investigative work. It's beyond just like, here's a story and we're going to talk about it and go, wow, this is crazy. Like, they're actually going and getting this information. So incredibly important work that they're doing. And they're showing us the tangible impact it's having on real people, which can't get enough of that. So, and then misdemeanor. Let me share misdemeanor's link really quick. Miss Janet Demeanor. All right, so Dana was on yesterday, and it was about 2 hours. It didn't feel like that at all. It went by really, really quickly. It was a great interview, easy to listen to. It was just Dana spilling a bunch of tea. So don't let Dana fool you and tell you he doesn't know how to do this podcast thing. He's great at what he does. So Miss D and Dana also linked in the chat. And if you're, you know, after the stream ends here, I find it easier to type Miss Janet Demeanor to pull up her channel than just typing Misdemeanor, because you'll get like Missy Elliott videos if you do it that way. So there we go. There's my my tip there. And then Factual Lie says, Lana from Truth and Transparency did a great stream titled Holly Bobo Bombshell, the Mother of All Lies. So I have not checked that out yet. But thank you, Factual Lie, for sharing that one, because it's going to have to go on my watch list. So that being said, and no, I don't know. I don't have an update on, you know, we still have Judge Bradbury. He's got like a month and a half for his 90 days that he's got to issue a well thought out opinion on everything that he's being asked to consider. But of course, as soon as I hear an update, I will be running to go live. It could be like 2 in the morning. If I'm in my car, I'll go live from my cell phone. like whatever it is, I'll be out. I'll be like, guys, there's a decision, and we'll see what it is. So there has not been an update yet, but when there is, I will run here to you guys. Also, Sheriff Chuck sending us on our way with 5 gifted memberships. Big thank you to Sheriff Chuck. He hopped over on Twitch for a second earlier, and he's like, hold on, I don't think I can gift over here. So came back over here, and the good thing about YouTube is we have these fun party Chuck emojis. So if you're a member, and especially if you just became a member because of his generous gifting, you can drop a party Chuck emoji in the chat to celebrate. Where is it? Where's my Chucks? Get some Chucks going. And then last but not least, I mentioned it in the chat while the oral arguments were playing, but Taybiz TV is going to be live today talking about the Michael McKee case and clerical errors. So who doesn't love a good clerical error? So that'll be at 6 p.m. Eastern today. So that's like 5 hours away from now. So make sure you keep that on your radar. Come hang out with us at 6 over at Tabiz TV's channel. And other than that, guys, yeah, all the Chucks flooding the chat. I'm going to send us over. We're going to go over to Classy. I think he has Brendan Banfield on his thumbnail, and he's talking about a few different things. So you guys know his morning show is a compilation of different stories. So I don't know exactly what he's talking about at this moment, but I'm going to redirect us over there and say hey, and we'll find out. So see you tomorrow for Banfield or something else. Bye, guys.